Judge Gibson of the Pretrial, and I'm ready to start if you are.
Yes, Your Honor, I am.
Okay, so yesterday the public defender actually called the cases because there was something with who was in the courtroom versus who wasn't. And I don't know if my cases are all in order, so if you want to do that, you can.
Yes, Your Honor, I'll try and keep it as in order as possible.
Okay.
If we could do Sophia Ales first.
Okay, that is who I have.
And they're going to bring her back from the back.
Is she approaching?
Yes, Your Honor. And I do have some PC arguments, Your Honor.
All right. I'm still struggling to hear there. Is there anything we can do about the sound? Yeah, it's very, they're light, they're soft, and it cuts in and out. Does anyone know?
No, I know they get a delay. Oh. Delay. So that's all. But I don't know how to do that. I mean, they have to go to the film.
All right, I'm just going to need you to get as close as you can to the microphone. I'm sorry, I want to make sure I can hear everything you're saying. All right, good morning, Miss Alley's. My name is Judge Gibson. You're here today. I can't find the case number. Oh, I don't have it. Okay. So you're here charged with burglary, with assault or battery, resisting an officer with violence, and escape. Has the public defender previously been appointed to represent her?
No, Your Honor.
All right. I'm going to appoint the public defender to represent you provisionally. You'll have to complete the affidavit of indigency. I understand that the public defender might have some arguments she'd like to make at this time, so I'll hear those.
Yes, Your Honor. So, with the burglary, with assault or battery, she was invited into the home. There is no indication within the police report that she the alleged victim in this case had the ability or the authority to keep her from the premises. As to resisting with violence, there is no overt violent acts. There is merely the tensing of her body and falling. And as my client has just informed me that those could have been due to seizures, as she does get those. So at this point, well, I do believe that there would be PC for a battery. The burglary, there was no indication that the alleged victim had the ability to keep her from the house. And as for resisting with violence, there were no overt acts, but there would be resisting without.
All right. State of Florida. Something happens with the sound. I don't know if you muted or didn't mute.
Yes, Your Honor. When my client has something to tell me, I do mute the mic. So, like, right now, I'll mute the mic in just a moment. And now it's unmuted again. Is it causing
Yeah, it's causing a lot of sound issues on our end. I can't hear you or your client, so I don't think you have to worry about that. Perhaps just step back away from the microphone if she wants to say something to you, and don't press the buttons because it's causing a lot of sound issues on this end. And let's try that.
Yes, Your Honor. Yes, Your Honor. We'll try that.
Okay. All right. State of Florida, please announce yourself and then if you have any responses.
Yes, Your Honor. Austin Anderson for the state. If I can just have one more second. Your Honor. Okay, so with the burglary, the assault, or battery, here, I mean, if you follow the statute, it clearly states. Sorry, I just had it up. That burglary means entering or remaining in a dwelling or structure or conveyance with intent to commit an offense therein, unless the premises are at the time open to the public or the defendant is licensed or invited to enter or remain. Here it very clearly states that it was not her residence and it was not open to the public. When she came into the house, even after she was told she was not allowed, she then decided to strike the victim there and also the trespassing with that. To go along with the resisting officer with violence, it goes with the escape when she came out and she attempted to flee and she managed to get her left hand out of the handcuffs. And that's when she was preventing the officer from arresting her at that point, to the point where he needed to pepper spray her. He did say, like, when she got out and she ran and she fought, or she was preventing him, he did say that it was violent. And with those violent acts, I believe that there would be PC to hold on the resisting officer with violence.
Your Honor, may I respond to that?
Yes.
Your Honor, all the acts that the officer describes are all of tensing and being incapable of putting her legs into the car. Running is not an inherently violent act. Neither is the tensing of one's body. Usually when you see a resisting with violence charge, you usually see something as striking the officer or doing something of that nature, not the mere passiveness of tensing one's muscles.
All right, I appreciate the arguments from both sides. At this time, I am going to find that there's probable cause on all 3 counts. As to the burglary with assault or battery, if you read the probable cause affidavit, it does state that she was not allowed in the house. She entered the house, and therein she did batter someone. As for the resisting with violence, I hear your arguments, but he does describe her as violent. He uses that word. So at this time, I'm going to find that there's probable cause.
Yes, Your Honor. We would be asked that bond be set at an appropriate amount in each case.
All right,
each
so
charge.
on count 1, is burglary of a dwelling with a battery a life felony? State Attorney,
I'm looking at the thing right now. I'm sorry.
I believe that's a life felony.
Your Honor, yes, it is.
Yes.
Yeah. Does the state wish to be heard on proof evident presumption grade?
Your Honor, we are not prepared for an Arthur hearing at this time, and we would not like to go forward on that at this time.
All right, then, based on what I read in the affidavit and the state's already argument on the probable cause challenge, I'm just going to find that at this time the state has met their burden. We will not have the Arthur hearing, and I'll defer that hearing to when it's assigned to the judge, and that gives the defense the opportunity to prepare and have that hearing at that time. So I'm going to leave the bonds as they are currently, which is no bond on count 1, $1,000 on count 2, and no bond on count 3.
Your Honor, escape she is entitled to bond on, I believe, as it is not a life felony.
I believe you're correct on that.
No bond unless set by the judge's second degree, Your Honor.
I'm going to set her bond on count 3 at $50,000. All right, thank you, ma'am.
Yes, Your Honor.
Next.
Your Honor, we have Jennifer Bowen. She's also in the back. And I believe it's a warrant case, Your Honor.
It's a what case?
Warrant, Your Honor. Warrant.
Warrant.
All right. Yes, it is. Wow, this sound is.
It's hard.
Your Honor, Pat Hill on behalf of PTR. I did fax over the narrative on that warrant for your convenience.
Thank you. Yes, I actually reviewed that warrant. I'm familiar with the facts. Is Jennifer Bowen there?
Yes, Your Honor, she's being brought up.
Okay.
They had the ladies in the back.
Yeah, I got plenty of time. All right, good morning. Can you please tell me your name?
Jennifer Ashley Bowen.
All right, Ms. Bowen, you're here on a warrant for sale of drugs, possession of cocaine, and also possession of a controlled substance, to wit, morphine. I see that you don't qualify for PTR. Would you like the public defender to represent you?
Yes.
All right, I'm going to appoint the public defender to represent you. Does she have an open case?
Yes, Your Honor. She is out on bond. However, the date of offense of this warrant is prior to her bonding out on the prior case, so it would not violate her conditions of release on the case she's out on bond on.
Okay. All right, thank you for the information. So,
What's the case number, so you'll take no action on it?
the Osceola case,
The case that she says she out.
20 CF 2621. Yes, I'm taking no action on that case at this time. I'm going to leave her bonds as in the warrant. So that's $7,500 on count 1, $1,000 on count 2, and $1,000 on count 3. Thank you,
Your Honor,
ma'am.
is there any way to lower that, or would this be a bond hearing in front of the judge?
It'll have to be a bond hearing in front of the judge assigned to the case.
Yes, Your Honor.
Thank you very much.
We have Carlos Aponte Ortiz is the next.
And he needs the Spanish interpreter, Your Honor.
Do we have more defendants who need the Spanish interpreter?
Yes, Your Honor.
All right, let's do all of those cases at the same time. Are they all in the courtroom, or do we need to have him wait?
I believe that they are all here, Your Honor.
Who
Yes.
needs the Spanish interpreter?
Espanol?
¿Cómo se llama?
I know, I'm going to, but I want to make sure we have if that's what we're going to do right now, because I want to do them all together.
Miguel De La Cruz.
Miguel Garcia. Gotcha.
So are you guys ready for me to call the interpreter and do all those cases at once?
Yes, Your Honor.
All right, I'm going to call right now.
Good morning, Your Honor. This is the Spanish interpreter.
Good morning, ma'am. Thank you for being here today. Have you previously been sworn?
No, Your Honor.
Do you swear or affirm to accurately translate from English to Spanish and Spanish to English all that transpires in the courtroom today?
Yes, that's my ability, Lord Royal State Certified Interpreter.
All right, thank you. I believe we have several individuals in need of your service, so we'll call them one at a time, starting with Carlos Aponte Ortiz. Sir, you're here today charged with possession of heroin and possession of drug paraphernalia.
Señor, se encuentra usted aquí hoy día por tenencia de heroína y tenencia de adminículos de droga.
Did he complete the affidavit for the public defender?
Yes, Your Honor.
¿Acaso él llenó la affidavit para defensor público? Sí, su señoría.
All right, sir, I'm going to appoint the public defender to represent you. I find there is probable cause for these offenses. If you're able to bond out, I'm going to leave your bond at $1,500 on count 1, $500 on count 2.
Muy bien, señor. Se le asigna defensor público para representarle a usted en estas causas. Se determina que existen indicios de criminalidad para sustentar los ilícitos y con respecto a la fianza se fijará para el primer cargo una fianza de 1.500 y para el segundo 500.
Your Honor,
Yes.
I believe that he does qualify for pretrial release, Your Honor. So if we could just do a direct pretrial release.
Su señoría, si no me equivoco, él cualifica para la libertad provisional. Por lo tanto, solicitamos que vayamos directamente a libertad provisional.
Yes, I just saw that and I will do that.
Así es, lo acabo de ver y se hará.
So I'll place him on
Thank you,
pretrial release.
Do you
Por lo
remember
tanto, se le concede libertad provisional.
Your Honor, is there any conditions attached to the PTR?
Su señoría, con respecto a la libertad provisional, ¿habrá alguna condición conexa?
He's not allowed to possess any controlled substances without a valid prescription and random drug screens.
Estará prohibido la tenencia de ninguna sustancia regulada sin receta médica y se le hará controles de orina de manera aleatoria.
Thank you, Your Honor.
All right, thank you.
Gracias, su señoría.
Your Honor, the next one down the list, Brooks is in quarantine procedures. So if we could reset him.
All right, let's do that. We'll reset him for tomorrow.
Oh, yeah. And then the next one we have is Miguel De La Cruz.
Good morning, sir. Please tell me your name.
Señor, buenos días. Por favor, indique su nombre.
Miguel Ángel de la Cruz García.
Acérquese al micrófono. Repita.
Miguel Ángel de la Cruz García.
Miguel Angel de la Cruz Garcia.
All right, good morning, sir. You're here today charged with, you're here today on a warrant for your arrest.
Buenos días, señor. Se encuentra usted aquí por una orden de aprehensión para su arresto.
Just kidding, I'm looking at the wrong affidavit.
Ah, me disculpo, estaba mirando la affidavit equivocado.
One moment, please.
Un momento, por favor, señor.
There he is. I know, but I thought I had it in my hand and I just didn't. So let's try this again. Sir, you're here today charged with DUI.
Muy bien, vamos a comenzar desde el principio. Se encuentra usted aquí por conducir bajo los efectos.
I find there is probable cause for this arrest.
Determino que existen indicios de criminalidad para sustentar el arresto.
Did he complete the application for the public defender?
¿Acaso llenó él la solicitud para un defensor público? Sí, su señoría.
I'll appoint the public defender to represent you.
Muy bien, se le designa defensor público para representarle.
I'll place you on pretrial release with special conditions. You're not allowed to drink any alcohol, random alcohol screens. You're not allowed to drive, sir.
Muy bien, se le va a conceder libertad provisional con ciertas condiciones particulares. Es decir, que usted estará prohibido consumir alcohol, se le van a hacer controles de orina de alcohol y usted no podrá conducir.
All right, do you understand?
¿Entendido?
Sí.
Yes.
All right, thank you, sir. Good luck.
Gracias, señor. Buena suerte.
Gracias.
Thank you.
What's your name? And then we have Nicholas Hernandez Orlean.
Hernandez Orlana. All right, good morning, sir. Please tell me your name.
A ver, señor, buenos días. Indique su nombre, por favor.
Nicolás Hernández.
Nicholas Hernandez.
Sir, you're here today charged with battery. Did he complete the affidavit for the public defender?
Señor, usted se encuentra aquí porque se le acusa de agresión física. ¿Acaso se rellenó el affidavit para defensor público?
Yes, Your Honor.
Sí lo hizo, su señoría.
All right, I'll appoint the public defender to represent you. I find that there is probable cause for this arrest.
Muy bien, se le designa defensor público para representarle y se determina que existen indicios de criminalidad para sustentar el arresto.
He does not qualify for pretrial release. I'll set bond at $500. If he's able to post the bond, sir, you're not allowed to have any contact with the victim. You're not allowed to return to the scene of the incident. You're not allowed to possess any firearms, ammunition, or weapons of any kind.
Muy bien, señor. No se le concederá libertad provisional, pero sí se le fijará fianza de $500. Si usted logra depositar esa cantidad, sepa que está prohibido tener ningún tipo de contacto con la víctima, estaría prohibido regresar al lugar de los hechos y estaría prohibido tenencia de armas de fuego o munición.
Do you understand, sir?
¿Entendido, señor?
Sí.
Yes.
All right, thank you. Good luck. Who's next?
Muy bien, muchas gracias y buena suerte.
Your Honor, if the interpreter could make an announcement to make sure that we have covered everybody.
Yes. ¿Hay alguien más en la sala que requiere un intérprete de español? Si es así, levante la mano.
Your Honor, I see no hands, so I believe that's all that we need for these services of the interpreter today.
All right, thank you very much, ma'am. We'll probably have to call you back for Orange County, but at this time, we're done.
Okay.
Have a nice day.
You too, Your Honor.
All right, who's next?
Brown Alejandro, which this is also a warrant case, Your Honor.
Yes.
Good morning, Your Honor.
Good morning. Please tell me your name.
Alejandro Brown Jr.
All right, sir, you're here on an arrest warrant for, it looks like, failing to appear. At this time, sir, I'm not going to disturb this warrant. I believe there's no bond set in this case. I'm going to leave that, and you'll have to have a hearing in front of the judge who will be hearing your case. Do you understand?
Ma'am, I came to court. When I came to court, they told me I came to court here on the premises, so I didn't have to go to court outside. So then they
Sir,
gave
can
me
you get
another
closer to the
court.
microphone? I can't understand you.
Oh, I'm sorry.
It's okay.
Ma'am, I came to jail. When I came to jail, they gave me a court date. I came to the jail, the first appearance was here. They had me set up for another first appearance outside. When I came to the court, they told me I sat in front TV, downstairs by the lobby, and they told me I don't have to go upstairs because I already did my first appearance. So I went to my probation, my attorney, my public defendant.
Sir.
And I went to her.
Sir, before you say anything else, I want to advise you that everything you're saying is on the record right now, and at this time, this court is not in a position to change the warrant. It was signed by another judge. It was ordered by another judge. So the more you talk, the more you could risk saying something that will be held against you later.
Okay.
Do you want me to appoint the public defender to represent you?
Your Honor, I believe we're already appointed on this case. I believe that
Okay.
this might have been incompetency, Your Honor.
All right, sir. Then what I'm gonna do is I'm gonna ask your attorney to make a note for the public defender who's actually representing him. If you can make a note right away, we want to make sure that we get if there's an evaluation that needs to be done, or if there is one pending,
Yes.
we need to get that in front of the judge.
Yes,
So
Your Honor.
what I'm saying, sir, is I don't want you to say anything that puts you in any risk of saying something you shouldn't say, okay? So I'm just going to ask you not to say anything else. Your attorney right there who's standing next to you, she's going to talk to her colleagues, and we're going to get your case moving as fast as we can. Do you understand?
Yes, Your Honor, I will speak with them in the morning.
And Your Honor, there is actually two cases on the failure to appear, two separate.
All right, so on both of those cases, I'm not going to disturb the warrant at this time. So they'll both have to be addressed by the judge who's hearing these cases.
Yes, Your Honor.
All right, go ahead and have a seat, sir. Thank you.
I believe the next we have is Edmund Gaspard.
Good morning, sir. Please tell me your name.
Edmund Gaspard.
All right, sir, you're also here on a warrant for, it looks like, fraudulent use of a credit card and grand theft. I just got that warrant. Hold on one second. Let me look at this.
Your Honor, also, I'm informed that he would qualify for direct PTR.
With a warrant?
Based on the charges, Your Honor. And the grand theft charge, the statute now reads that it should be a $750 to qualify for grand theft. So this should have been a petty theft, Your Honor.
I need to see the warrant itself because that may be an argument that you have to make to the judge actually assigned to the case.
Yes, Your Honor.
And for the record, the state already filed on the grand theft charge, and I included the information along with the narrative of the warrant.
Oh, Your Honor, I am thinking of an entirely different case. I apologize to the court.
That's okay. And actually, it accuses that the value is $750.
Yes, Your Honor, I realized, I was like, wait a second, I thought I had more to read with this one, so I apologize to the court.
All right, so what's the reason for the capias? Does anyone know?
Your Honor, I don't have the warrant. I just have the arrest affidavit. Yes, please. If you would give me just one moment, Your Honor.
Okay, because I don't see the warrant either. I have the arrest affidavit and I have the information.
I did include the narrative along with the information I scanned. I can rescan it if you like.
Is there,
Hold on, let me read this.
if there's a case number, I can look it up in our Osceola.
20 CF 2910A.
And then he goes on this one, so they state filed on it, I think this one should be about narrative now.
Right. I see the narrative, but I'm trying to figure out what was the reason for the capias.
Your Honor, this appears as if it was a long outstanding investigation from what I'm reading.
Okay.
And that this might have been the first time that he had been arrested on said charge.
It is the first
All right.
time.
So this would be the first interaction with this system that he's had and it's been filed on.
So a judge has not set bond in this case?
Correct, Your Honor. There was no capias
it was
on
signed by a
this.
judge.
Oh, no,
Bond
yes,
was
yes, Your Honor.
set on the capias in this amount by another judge. So
Yes, Your
I understand that he qualifies for pretrial release, but I think you're going to have to make that argument to the judge who's actually assigned to the case.
Yes, Your Honor.
Count 1 is 500, count 2 is 500.
Right, so count 1 is 500, count 2 is 500. If the PD wasn't previously appointed, I will appoint them to represent you, sir,
Thank you, Your Honor.
and then they can file a motion for pretrial release on your behalf. Do you understand? Do you understand, sir?
Yes, ma'am.
Okay, sorry, it's really hard to hear you, and I want to make sure I hear everything. So thank you very much. You can have a seat.
The next that we have is Garen George, or George Garen.
Somebody George. Who?
This is an out-of-county warrant, Your Honor.
Hold on, I'm trying to find a George. Oh, got it. All right, this is an out-of-county. Could you please state your name for me?
Gary and George.
All right, sir, you're here on an out-of-county warrant, and it looks like a VOP. So at this time, I'm not going to disturb that warrant. It's a Seminole County, so it'll have to go back to Seminole County, or the judges can work on something here. But since he's a violent felony offender of special concern, I'm not setting any bond today.
Yes, Your Honor, I understand.
All right, thank you. Good luck, sir. Oh, I'll appoint the PD to represent him.
Yes, Your Honor. The next we have is Jonathan Guerra.
This is totally out of order. That's what happened yesterday with Osceola. They're doing it in a different order.
Let me just say, just go by what's, this, just go in order. Cartos, can you tell me what happened to COTTO Cartos? Did he bond it?
Ma'am?
First name is, which one you got over there, Judge? That's out of order. You keep flipping over.
This one. Nope, wait.
This person,
Alejandro Brown.
Brown,
Did we do Brown?
Yes, Your Honor, that was the one that we asked for reset. He
Okay.
was, oh, no, Alejandro Brown, yes, Your Honor, we did do that. It was the FTA, there was a 0 bond, you maintained that bond.
Okay. And who is this?
This is, Jonathan, Guerra.
So ask him what this person is.
Where's Beatrice Cato?
She bonded.
Okay. Oh, good. Take her. Thank you. Jonathan.
You should be on top.
Oh,
I'm trying to put in the order, because she's going to order now.
okay. Thank you. All right. Sir, could you please tell me your name?
Jonathan Guerra.
All right, sir, you're here today charged with operating a motor vehicle without a valid driver's license. Having reviewed the affidavit, I do find that there's probable cause. Would you like me to appoint the public defender to represent you?
Do you want a lawyer?
No.
Did you say no?
Yeah.
Yes, you would like me to appoint them?
It's up to you.
Yeah.
Did you complete the affidavit, sir?
Yes, Your Honor, he had completed an affidavit.
Okay. I see that he qualifies for pretrial release, so I'll place him on pretrial release. Sir, you can't drive. You don't have a valid driver's license. So until you get that, you're not allowed to drive in the state of Florida. Do you understand?
Yes, ma'am.
All right, good luck. Have a seat.
Yes, Your Honor, the next that we have is Medital, and Your Honor, we would waive the reading of the charges. Oh, no, I'm sorry. He's coming up, Your Honor. What we have is, he's not here right now. What we have is Jedediah Parks.
Wait. What happened with Britt Matatal?
Your Honor, he was in a separate area of the jail, and they're trying to keep them separate for quarantine purposes.
Okay, so is he coming
he's
today?
not- Yes, Your Honor, he's there. They are going to bring him up.
Okay. All right, so who's next?
Jedediah Parks.
Good morning, sir. Please tell me your name.
Go ahead, tell them.
Can you please tell me your name, sir?
Jedediah Parks.
All right, Mr. Parks, you're here charged with DUI and refusal to submit to a lawful test. Did you fill out the affidavit for the public defender?
Yes.
Would you like me to appoint them to represent you?
Yes.
All right, I'm going to do that at this time. I see that he meets the criteria for PTR.
Your Honor, we did attempt to release him prior to IA's on admin PTR, and just for the record, he refused that.
Okay,
So,
sir.
it's up to you if you want to give him PTR or not.
You don't want to be placed on pretrial release, sir?
Well, I do have someone coming to bond me out right now.
All right, so then I'll leave the bonds as they are set with special conditions that you're not allowed to drink or possess any alcohol. And don't drive, sir.
Yes, sir.
All right, good luck. Thank you. Who's next?
Miguel Valle.
Good morning, sir. Please tell me your name.
Miguel Valle.
All right, sir. You're here today charged with battery. Did you complete the affidavit for the public defender?
Yes.
Would you like me to appoint them to represent you?
Yes.
All right, I'm going to do that at this time. After reviewing the affidavit, I do find there is probable cause for this arrest. Does he qualify for PTR? No, he doesn't qualify for PTR.
No.
All right, so at this time, I'm going to set your bond, sir, at $1,000 with special conditions that if you do bond out, you're not allowed to have any contact with the victim. You're not allowed to return to the scene of the offense. You're not allowed to possess weapons, firearms, or ammunition.
Hi.
And that's it. But you're not allowed to have any contact with the victim. Do you understand, sir?
Yes. Yes.
All right. Good luck, sir.
Thank you.
Next.
Carl Zamor.
Good morning, sir. Please tell me your name.
Carl Zamora, Your Honor.
All right, sir, you're here today charged with burglary of an occupied structure and criminal mischief. Did you complete the affidavit for the public defender?
Yes, Your Honor.
Would you like me to consider appointing them to represent you?
Yes, Your Honor.
Okay, and all right, I'm going to appoint them to represent you at this time. It says he meets the criteria for pretrial release.
That's correct, Your Honor.
All right, I'll put him up to pretrial release, but I'm going to combine that with monetary bond.
What does that mean, Your Honor?
It means that you'll still have to bond out, but you'll also be on pretrial release if you do, so you'll have special conditions that you have to abide by while you're out on bond.
Okay.
So currently, your bond on count 1 is set at $5,000, and because I'm going to place you on pretrial release, I'm going to reduce that to $2,500 for count 1, still
Thank you, Your
$500
Honor.
for count 2. So I cut your bond, but you're not allowed to have any contact with the victim. You're not allowed to return to the scene. Was there any allegation of alcohol or drug use in this?
Yes, I mean, Your Honor.
No.
Your Honor, I don't believe so.
I don't
I can't recall.
I don't recall that. Okay, so sir,
Your Honor, may he have a one-time return? His vehicle is at the scene.
yes, you may return one time with the assistance of law enforcement. So you can't go there on your own and you can't coordinate it with the victim. Do you understand?
Yes, Your Honor. Would I be also able to just have somebody else go get the car?
Yes, but you can't have any even third-party contact with the victim. So you can't use that person to contact your victim.
I understand completely, Your Honor.
Okay, all right. So yes, but if you aren't able to coordinate that, pretrial release will explain to you how to do it with law enforcement as an escort so that you can go back one time.
Thank you, Your Honor.
Yes, sir. Good luck.
The next
right.
we have is
Who?
Justin Kanya?
Yes. Good morning, sir. Please tell me your name.
Justin Kania.
Kenya.
All right, sir. You're here charged with possession or use of a stolen credit card, petty theft, fraudulent use of a credit card, and fraudulent use of personal identification information. Did he fill out the affidavit for the public defender?
Yes, I have.
Yes, Your Honor.
All right, I'm going to appoint the public defender to represent you. You do not qualify for PTR, and it looks like you have some other pending charges. I'm going to leave your bonds undisturbed. All right, so your bonds are going to remain as they are in the warrant. If you are able to bond out, you're not allowed to have any contact with Patrick Eli, and you're not allowed to return to the locations of the offense. Do you understand?
Yes, ma'am.
All right, thank you, sir. Good luck. No, he's a co-defendant. We saw him yesterday.
The next is, the next would be Kenneth Navarro. Your Honor, we would waive the reading of the charges.
Kenneth Navarro. Just a moment. Sir, can you tell me your name?
Kenneth Navarro.
All right, sir. Did he fill out the affidavit for the public defender?
He did, Your Honor, and I would ask to be appointed for this hearing. He has indicated that he is hiring a private attorney, though.
All right,
But
sir.
they are not present.
You have the money to hire an attorney?
Yes, ma'am.
So then
Yes, ma'am.
you don't want me to appoint the public defender for you?
She said just for the purposes of today.
Yes, Your Honor. For the purposes of today, I would ask that we be provisionally appointed because he does not have counsel at this time.
I can, but that's not how that works. you have the money to hire an attorney, you hire an attorney. All right. I'll provisionally appoint the public defender to represent you for purposes of this hearing. Madam Public Defender, do you want to be heard?
Your Honor, I do not argue that there is PC.
I'm sorry, I could not hear that. You are not arguing?
I am not arguing PC at this time, Your Honor.
Okay. And does the state wish to be heard on any of these charges? Are these first-degree felonies or punishable by life or capital?
Your Honor, as they're listed, they are not capital
I don't
offenses
believe
at this
so.
time.
Okay.
All that we ask is that there's bond set on the charges.
All right. Does the state wish to be heard on bond?
Yes, Your Honor. We'd be asking for either a no bond or a high bond with the circumstances and facts of this case, especially a no return and no contact if there is a bond placed and he's able to bond out. And note, I believe there might have been alcohol, possibly. It was intoxicated. Alcohol, no alcohol, no drugs, no weapons, if bond is ever been able to get set.
Your Honor, we have no argument with no contact and no return at this time. He does have another location, another place that he can go and stay, but we do ask that bond be set.
All right. Based on the charges as written currently, I'm going to set bond on count 1 at $10,000, count 2, $10,000, count 3, $1,000, and count 4, $10,000. If you are able to post bond, sir, you're not allowed to have any contact with the victim. That includes third-party contact. You're not allowed to return to the scene for any reason. And you're not allowed to drink or possess any alcohol.
Your Honor,
Yes.
in order to get personal effects, would there be a one-time return with law enforcement with no contact with the victim?
Sir, do you have personal effects at that residence?
Yes, ma'am, I live there.
All right, I'll allow one-time return with law enforcement. But you understand that what that means is you are still not allowed to have any contact, third party or otherwise, and you cannot return without the police with you. If you return to that residence without an escort of law enforcement, your bond will be revoked and you'll be held on no bond. Do you understand?
100%, ma'am.
Okay, all right, thank you. Yes, for any reason other than the one time to retrieve belongings with law enforcement.
Your Honor, we did just have Matella come in. We just need one moment to talk to him. I've not had a moment to talk with him. If I could have 5 minutes, Your Honor.
Can we do all the other inmates that are there and then do him? Is that possible?
Yes, Your Honor. Everybody else has happened. Let me see this one bonded.
All right, I just want to make sure we don't. I'd rather clear out the room if that's possible.
Hammond is in detox, Your Honor, so I would ask for a reset.
All right, we'll reset him for tomorrow.
Perez is also in detox, and we would ask for that to be reset.
Yes.
And then Vanette, also detox? What? Oh, and Your Honor, and then Vanette cannot be brought up at this time.
Jude Venant.
Okay, Your Honor, I would ask this to be set one more time. I need to talk to my supervisor about a thing regarding this case, and I would ask just to be reset once more for tomorrow, and I will speak to my supervisor.
Is that on Jude Venant?
Yes, Your Honor.
All right, I'll allow that, so we'll reschedule him for tomorrow. So then the only person we have left is Britt Metala.
Yes, Your Honor. And I just need 5 minutes to speak with him briefly.
All right, court will be in recess for 5 minutes.
So he come full handle.
All right, wait, we're back on the record. Is Osceola County ready?
Yes, Your Honor.
Yes, Your Honor.
All right, let's call the last case.
It's going to be Matitol Britt, or Britt Matitol. Hang on.
All right, sir, can you please tell me your name?
The what?
Your name.
My name is Britt Matitol.
All right, sir. You're here today, charged with sexual battery. Did he fill out the affidavit for the appointment of the public defender?
Yes, Your Honor, that was one of the things that I was doing.
Okay, all right. Then I'm going to appoint the public defender to represent him. I do find probable cause after reviewing the affidavit. So, does the state wish to be heard on bond?
Yes, Your Honor, it's the same as last time, same argument. We would be asked for no bond on this. However, due to the facts of the case and the circumstances, also if there is a bond, we'd ask for it. Leave it in your discretion. However, we ask for a high bond. With that, the same no contact, no return, no all of those conditions for sure if he can reach the bond.
Your Honor, the defense would be asking for bond on this case. He is a older gentleman, and he currently, as you can see, is seated in a wheelchair. This is not a punishable by life felony, so we would ask for bond be set in this case.
All right, at this time, I'm going to set bond in this case in the amount of $15,000. Sir, if you're able to bond out, you're not allowed to have any contact with the victim. You're not allowed to return to the scene of the offense for any reason. Do you have belongings here?
No, it's where I live. It's where I live. That's where it's called. I was in bed and they called.
Your Honor, the alleged victim does not live at the residence. From what PTR is telling me, it would be his residence.
Yeah. All right, then I'm going to order that you maintain separate residences. You're not allowed to have contact with her for any reason, even through a third party.
I have no intention.
I'm sorry?
He said he had no intention of, Your Honor.
Okay, I'm sorry. The sound is really bad, so it's unclear at times. Sir, you're not allowed to possess weapons, firearms, or ammunition.
I don't.
All right.
It's okay.
All right. Any other conditions that the state...
Your Honor, just so you're aware, with the facts, there was a BB gun there in the facts, in the affidavit, there was a BB gun. He has at that. So if he says he doesn't, we just need to make sure that is considered a weapon and out of the residence as well.
All right.
Your Honor, the fact that there was a BB gun present was the other gentleman that was coming to the home. It was not his BB gun at all. It was the alleged victim's friend whom she called.
That's what
who
I
had
thought.
that weapon. Yeah.
Okay, yeah.
But just to be clear, a BB gun is a weapon and you're not allowed to possess that. So when you get home, if there's a BB gun, you can't have that. You understand? And also, he can't have any contact with the witness either.
Yes, Your Honor.
All right. Thank you very much. Good luck, sir.
Yes, Your Honor, and that, I believe, concludes all that we have in Osceola today.
All right. Thank you, counselor. Have a nice day.
Yes, Your Honor, you too.
They cannot hear out there in the gallery, so we have to alert them and we have to beat them or whatever.
Okay.
They can't hear us. It's not going to call, it's not working.
Okay.
They still not.
How do we know?
I'll let you
How do I know that there's a victim for a case?
Well, we know that we want to.
Okay, so you'll just let them know? Okay. All right. Thank you.
I have a question for you. It's not a domestic case. but it's a violation of pretrial release on one of mine. They said that they were gonna come
I
and
have some people that's here for,
a witness tampering or something. It's not.
what's his name?
I was just making sure that they were able to get in. One of the case or the witnesses.
I have somebody here for this person.
Yep. Yeah, I believe that's it. Okay. I just think because the attorney holding it wanted me to make sure they got in.
No, he wanted to hold. So who gonna be with David? Who's gonna be with? In the hallway. Oh.
Y'all ready? Y'all ready? Everybody ready?
Everybody ready?
Yep.
All right.
Ready, Yana?
No, because they're here. They come in. Is it a lot to move that TV? You can't move it? Okay.
Okay, roll it. Turn to the side.
It might move, I don't know.
I know, you ain't doing anything. Okay.
That's fine. I can't see the defense attorney because he's directly behind that, but it's okay.
Andy.
Do I go ahead and call the interpreter?
Yeah, we should have, two.
It doesn't move now.
They don't move.
Yeah, they have.
It's fine. I was just asking. It's fine.
Good morning, Your Honor. This is a Spanish interpreter.
Good morning. We have two, I believe, who need your assistance in Orange County. I believe he's wearing the headset. Can you ask him if he can hear?
Give me a second, Your Honor, to connect. And we've been having some problems, so
Right.
hopefully we won't have any today.
Right.
Sí,
He can hear me, Your Honor.
Good morning, sir. Please tell me your name.
Javier Ortiz.
Javier Ortiz.
All right, sir, you're here today on a warrant for failing to appear for court.
Okay.
Okay. Mm-hmm.
Can you ask him, does he make $1,000 a week?
Algo similar.
Something like that.
Ok, Missy, yo le quiero decir algo.
But I would like to say something.
All right, sir, first let me explain to you that everything you say right now is being recorded and can be used against you. Because this is a warrant arrest, I'm not in a position to change it today, so nothing you say today is going to change what this court can do. You would need to make an argument in front of the judge who issued this capias. Do you understand? Do you understand?
Sí.
Yes.
All right, so on the KPS, I see that the judge put your bond at $250. I'm not going to disturb that. I don't think you qualify for the appointment of the public defender. I'm not going to appoint them at this time. But you can always reapply in front of the judge who's hearing this case. Do you understand?
Okay.
All right, thank you, sir. Good luck. Sir, do you speak English?
Parle Creole. I don't parle English.
It's Creole, Your Honor.
It's real.
Oh, he speaks Creole.
1804, the year I was born. I'm sorry for being illiterate. Now, I mean it. Don't touch me, right, people?
Yes, sir. I understand.
Now, why am I in jail saying this? I was asked to be free.
Mr. Gonzalez bonded, Your Honor.
I'm sorry, what's his name?
No, Mr. Gonzalez,
Hold on, my bad. Sir, I mean, ma'am.
Sir,
Let's be real.
take a step back. Come on back to me. Horatio Gonzalez bonded, Your Honor.
Okay, so we don't need the interpreter anymore? All right, thank you, Madam Interpreter. I think that's all we need from you today. Thank you so much.
Okay, Your Honor, the interpreter will disconnect it. I won't be needed for any victims on DV cases, correct?
I don't know the answer to that, but so at this time I can't tell you that. We might have to call you back.
Your Honor, that's the point. I come to the courthouse for this, so once I disconnect, I'm no longer available.
Oh, they're gonna check right now.
Thank you.
My bad. Touch me. Banks. Kill me if you can now, Banks. What instruction did you give me out there? Don't touch nothing, okay? How can I speak?
What is his name?
Damn.
Darnell Sideline.
A liar.
Okay.
From the past tense word.
No one needs a Spanish interpreter, Your Honor.
No one needs.
All right, Madam Interpreter, I don't have any
I need a
victims
Creole
that need your
interpreter.
interpretation services.
A Creole interpreter. Do you have a foreign language from?
You don't speak English?
I don't speak English.
Okay, step outside.
I speak English.
No.
I understand English.
You
I
need a
speak
Creole-
honest.
Come on.
I need
Madam
to-
Interpreter,
no.
we don't need any more assistance from you. Thank you very much.
Yeah.
Thank you. I'm
Leave me in here, damn bitch.
Come on, citizens.
Told you I see you again.
Come on. I'm sorry, guys. Okay, I know Horatio Gonzalez bonded. You had another Roger Perez Gonzalez?
He bonded too.
Okay.
No, I'm sorry, he didn't. He was, he was mental health.
He mental health.
Yes.
Who?
I'm sorry, that is right here.
I'm so lost right now. I have stacks of paperwork that none of it's what, I don't know how I got it out of order. So, I don't know who that is. I don't know why this is here.
Hold on, put the picture back.
I don't know how I got it out of order.
Okay, that's what we just did. That's him.
Okay.
Okay, and then, okay, now this guy, he is mental health. Perez, okay, so he mental health, so I'm keep that one.
Okay, you can have
This
it.
is the guy that was having that she just took out.
Okay, that's this guy.
Yes.
Okay.
So this one here you don't need, because I'm gonna reset him because he mental health.
All right.
Okay.
And then for Darnell Sideline, or Sideline, in case number 2020 CF 12200AO. Does the public defender represent him? That's the gentleman who just left. Do you represent him?
I don't believe so.
He didn't fill out.
He can't fill out a form.
Oh, okay.
I'm going to appoint the public defender to represent him. I find that there is probable cause in the affidavit, but I think that the public defender's office probably needs to get him evaluated.
So he's waiving his appearance and we'll go ahead and do the IA.
Yeah, I'm going to waive his appearance. We'll do the initial appearance without his presence. I'll leave the bond as is, which is $1,000, and I appointed the public defender.
So I'm sorry, Your Honor. Now I'm kind of confused. Was that the Horatio Gonzalez is what we're doing that on?
No.
Oh. Okay, that's what I thought. And then, which one are we doing this one, that one on?
The gentleman who just left, Mr. Sideline.
Okay, thank you.
We got two cases. And the bond stayed on both cases, right?
Yes.
Okay, gotcha.
Oh,
All right.
okay, I thought that was Horatio.
So now, who's next? Roller.
Roll, yes.
Okay.
Okay.
Oh my gosh, I don't know what happened.
I know, it just.
Good morning, sir. Please tell me your name.
Daniel William Roller.
All right, sir, you're here today in 19 CF 7032AO for a violation of probation and in 2020 CF 12214AO for attempted burglary of an occupied dwelling. Sir, on the violation of probation case, I'm not going to disturb that warrant, so you'll have to address that with the judge who issued the warrant, who placed you on probation. In the other case, I see that you filled out this affidavit. I'm going to appoint the public defender to represent you. I do find that there is probable cause in this arrest. I'm going to put your bond in the attempted burglary case. Hold on, I can't get the paperwork separated. At $2,500. You're not allowed to have any contact with the victim. You're not allowed to return to the scene of the offense.
But I have no bond on the violation of probation, you said?
No, you don't have any bond on the violation of probation. And no return and no contact. Okay. All right, sir. Do you have any questions for the court?
Your Honor, on Sideline's second case, the bond was stayed at $250, correct?
2,500.
No, on the
On
guy that just left.
oh, Sideline.
Yes.
Yes. Sorry.
Thank you, Judge.
I'm sorry. I thought the other guy. Oh my gosh. All right, sir. Please tell me your name.
Jody Thompson, middle initial Hunter.
Good morning, sir. You're here in case number 20MO1055AO. And looks like you're out on bond on another case. The charge is resisting an officer without violence. I see that you completed the affidavit for a public defender. Sir, do you have a job?
Yes, I am Warden of Florida, Emperor Architects, Mayor of D-Land.
All right. I'm going to appoint the public defender to represent you.
Yes.
I'm going to revoke his bond on the open case. All right, sir. So you have a bond on the new case that'll be...
I already have a bond set for me. It's $250.
Yes, sir. That's what that'll be.
This is an ordinance or a misdemeanor?
It's a misdemeanor, sir.
It says ordinance on my paper.
But it's a misdemeanor. Yeah. So, yes, it's a violation of an ordinance.
What did I violate upon?
The
What?
probable cause affidavit.
I settled down. I settled down. I didn't.
Good, sir. I think that's wonderful.
I'm talking to the judge.
I think that the resisting charge is that you were not obeying the lawful commands of the police officers.
I did. I swear, Your Honor.
I believe you, but at this time, I'm not in a position to make a change to that. I think that
I'm
what
trying
you
to
need to
leave. I'm trying to leave Orlando this evening. I've been here for a month and 2 weeks already. I'm trying to get back to Daytona Beach. I got stranded by the police arresting me, saying I'm trespassed from Parliament House, and I have nobody here in Orlando.
I understand, sir. I'm not in a position to change that today. The only thing we're doing today is looking at the probable cause, which there is, and then I set a bond for you for $250. You need to
I
talk to
already
your
had
attorney
the
about your
bond,
other
though.
options, okay?
Oh, okay, fine.
Thank you, sir. Good luck. Yes. Yeah, it's all right. Thanks. Good morning, sir. Can you please tell me your name?
Henry Lacey.
All right, sir. You're here in 2020 MM 734480. You were arrested for trespass on property after warning. I do find there's probable cause for that offense. I'm going to appoint the public defender to represent you, sir. Does he qualify for pretrial release?
No, Your Honor.
Okay, hold on one second, sir.
Excuse me?
I just wanted to review something. All right. So I'm going to set your bond at $100. You're represented by the public defender. If you're able to bond out, you're not allowed to return to the Lynx bus station. Do you understand?
Well, I understand that, but I was robbed of my wallet and all my identification. And the only place that I could find here in this state was downtown there next to the city hall. And I can't get down to the city hall unless I take the bus.
Okay. Talk to your attorney about that. He may be able to help you with some other ideas, all right?
Okay. Well, I just wanted to explain.
All right. Good luck, sir.
Yes, sir. Thank you so much. Which way? Okay. Thank you, ma'am.
Yes, sir. Can you please tell me your name?
Bianca Vincent.
Yeah, she has a victim.
All right.
What's her name?
I don't have her face sheet.
Vincent?
Bianca Vincent. Maybe I don't need it.
Okay.
All right. Good morning, ma'am. You're here in case number 2020 MM 733680, charged with battery domestic violence. I see that you completed the affidavit for the public defender. I'll appoint them to represent you. Good morning, sir. Can you please tell me your name in the box?
Yes, first name is Marco, last name is Landum.
All right, can you raise your right hand, sir?
Yes.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And who's that with you?
This is my son, my three sons, Mikael, Marco, and Malik.
All right, thank you. Does the state wish to inquire?
Yes, I'm sorry. I was just grabbing, I was finding the file or the paper. This is Marco Landum?
Yes.
Okay, thank you. What's your relationship to the defendant?
She's my, I would say a partner. We've been together for 5 years.
Okay, and how, has anything similar to this happened in the past?
I'm sorry, what is it?
Has anything similar to this happened in the past?
Yes, we have been going through this for a few years now. We actually have a case back in Rhode Island. She took the kids and just left the state, and knowing that she wasn't even supposed to do that. So yes, we've been going through this for quite some time now.
If the defendant gets out today, would you be afraid?
I'm sorry, what is it?
If the defendant would get out today, would you be afraid?
I would not be afraid as long as she stays to herself and not bother me, because we have separate rooms. And for now, but I'm actually in the process of getting my own apartment. But as long as she stays to herself and doesn't bother me, and I'll stay in my room, she stays in her room, everything is fine.
And it's okay. So you don't want contact, or you do?
No contact. As long as the thing is, I know exactly what she's gonna do. As soon as she leaves, she's gonna start arguments again, and I'm doing everything in my power to avoid the arguments. And so as long as she, like I said, as long as she stays to herself, and if it's anything about the kids, she's more than welcome to talk to me. But if it's anything else, I don't want to talk, because all she wants to do is argue and argue and argue, and I don't want that.
Okay, I have no further questions, Your Honor.
Does the defense wish to inquire?
Yes, Your Honor. Do you both live in the same house?
I'm sorry, what is it?
You live in the same house?
Yes, we do, but we stay in the separate rooms, yes.
If the court ordered there to be no hostile contact between the two of you, do you think you would be able to abide by that?
Yes, trust me, I do. If she will tell you herself that she will not hear from me. I don't bother her. She's the one that's starting the everything. It's not me. She will tell you it's not me.
And if anything did happen, you'd call the police?
Yes.
Okay, no further questions.
All right, does the defendant qualify for pretrial release?
She does, Your Honor.
All right, ma'am. I'm gonna place you on pretrial release with the special conditions. Well, so, sir,
Yes.
if you live in the same house, having no contact is gonna be very difficult.
Yes, I know. When I say no contact, I just don't want her to argue with me. I like for the short time I have in that house, because I will find my own place and leave. It's just that I just don't want to argue with her. And as long as she doesn't argue with me, she can talk to me. But as long as she doesn't argue and I'm completely fine with that.
All right, so I'm gonna order no hostile contact.
To be apart because we live in the same house and I have to find my own place. So I will in the meantime. It's just that in the meantime while I'm there, as long as I don't want to argue with her, she can stay to herself and I stay to myself.
I'm gonna order no hostile contact, so peaceful contact only. Do you understand what that means, ma'am? You're not allowed to raise your voice at him. You're not allowed to touch each other. No violence at all. It has to be peaceful contact for the purposes of discussing arrangements for the children. Do you understand? All right, so peaceful contact. So then she is allowed to return to the scene. You're not allowed to possess any weapons, firearms, or ammunition. I don't recall seeing, there's no allegation of, is there, sir?
Yes.
Is there any alcohol or substance abuse involved in this incident?
No.
No, all right. All right, that's it. So, do you understand the conditions of pretrial release, ma'am? I'm sorry, you have to answer out loud.
I'm sorry, yes.
All right, thank you. Good luck. Thank you, sir, for coming. Correct. Thank you, sir, for coming. You're free to go.
Thank you. Yeah.
Good morning. Please tell me your name.
Joe Andrews.
All right, sir. You're here in 20 CF 12224.
Yeah, I need as a witness, I'm sorry.
Okay. Let me give her a minute to get here so she can hear me. Sir, you're here on a charge of battery on a person 65 years or older. I see that you completed the affidavit for the public defender. I'll appoint them to represent you. I do find probable cause exists for this arrest. Ma'am, can you please tell me your name?
Alice Laguerre.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Does the state wish to inquire?
Yes, Your Honor. Miss Lear, what's your relationship with the defendant?
He's my fiance.
I couldn't hear that. What?
I think she said it's her fiance, I believe.
Can you talk, can you?
He's my fiance.
All right.
And do you guys live together?
A little while. A little while.
Okay. How long have you guys been in a relationship together?
Almost 4 years.
Has anything similar to this happened in the past?
No.
Was there any children present when this happened?
All my children are grown.
Okay. Was there any alcohol or drugs involved?
Alcohol.
Okay. And if the defendant got out today, would you be afraid?
No.
If the defendant got out today, would you want contact with him?
To see if he could get a place to stay. He can't stay with me.
Okay.
He needs psychiatric care. He is a lakeside patient. He has schizophrenia. And other than that, he had been doing well. He hadn't been in any trouble in over 4 years. And I thought I was changing him for the better. But then I couldn't get him to stop. He was making too much noise outside my complex, and I'm in the project, housing authority, and I could lose my housing by him doing that. And he wouldn't listen. When he hit me, I could feel like he was kind of hesitating, like he didn't really want to do it. But it wasn't enough to push me down, you know. But he knows that my legs, I have rheumatoid arthritis, and I have diabetic neuropathy, and I'm a fall risk. And I just wanted to talk to him, just wanted him to stop. And he get like in spells when he drank too much. He went across town, and every time he go across town, he come back. He gets kind of rowdy. But I just go to sleep, and I wake up. He's okay the next day. So he need help. Because he's not a bad person, really. He's not a bad person. He helped me out in the house. He helped take care of me, because I get depressed that I can't do what I need to do in my house for myself. I have my son there. They don't do nothing to help me.
Okay, ma'am. So I just have one last question is, if he gets out today, you don't want him living in your residence, but you would be okay speaking with him?
That he'll cause me to lose my apartment. I need his help.
Okay. I have no further questions, Your Honor.
I couldn't hear that last bit that she said. What did she say?
She said no, correct me can you hear me, ma'am?
Mm-hmm.
Correct me if I'm wrong. She said that she doesn't want him to live with her apartment because she's afraid of losing the house, but she's not afraid of like verbal contact, like speaking.
No.
All right, does the defense wish to inquire?
No, Your Honor.
All right. Thank you, ma'am. I just want to make sure, I want to clarify. As a condition of bond, do you want me to order that he can have peaceful contact with you?
Yes.
All right, so I'll do that then. Does he qualify for pretrial release?
Judge, we tried to interview him last night, but he declined to speak with pretrial staff.
Huh. Is it possible to interview him? Is it possible to interview him, to try and interview him again, or no?
Would the courts be willing to consider setting a bond in case the defendant does not qualify for pretrial?
Yes.
Maybe a monetary bond or pretrial release if qualifies, if the courts feel that that's appropriate?
I can do that. I'm gonna ask his attorney. Is your client interested in being interviewed for PTR?
Your Honor, he is. I don't believe he's going to be able to afford a monetary bond.
I can't hear you. Can
time.
you
Oh,
put the
sorry.
microphone close to your mouth?
I don't believe that my client will be able to afford a monetary bond. He would like to be interviewed by pretrial release. He just wasn't aware of what it was at the time.
All right, then what I'm gonna do is I'm gonna set a monetary bond of $1,000, or in the alternative, pretrial release. If he qualifies for pretrial release, he can be released on that. If he does not qualify for pretrial release, then the monetary bond will be $1,000. Special conditions are, sir, you're not allowed to take drugs of any kind unless you have a lawful prescription. You're not allowed to drink alcohol at all. You're going to be subjected to random alcohol and drug screens. You're only allowed peaceful contact with the victim. So when I say peaceful contact, what that means is you're not allowed to raise your voice, you can't yell, you can't throw things. Do you understand?
Yes.
I'm sorry?
Yes, ma'am.
Okay. And you're not allowed to return to her residence. Do you understand that?
Yes.
Okay. Do you have any questions for the court?
You know how sensitive
You have any questions?
No, ma'am.
All right, good luck, sir. Thank you, ma'am, for coming.
Thank you very much.
Good afternoon. Please tell me your name.
Francisco Godoy.
All right, sir, you're here in 2020 CF 12216AO. You're charged with kidnapping, aggravated battery on a pregnant person, battery by strangulation, and false imprisonment. I see that you completed the affidavit for the public defender. I will appoint them to represent you. I do find probable cause exists. There's no one here, no victims here?
No.
All right. Does the state wish to be heard on bond?
Was there victim contact? I didn't see that.
Victim contact was made. It's not indicated whether or not the victim advised they intended to be present for court today.
Thank you. The state would just defer to the court in their discretion with the bonds, Your Honor. If there's a bond set, or I don't believe he is PTR eligible, just the normal PTR conditions with no contact since we're unsure.
All right, I am gonna set bond at $5,000 in count one. $5,000 on count two. $1,000 on count three. $5,000 on count four. Sir, you're not allowed to have any contact with the victim. You're not allowed to return to the scene. No weapons, firearms, or ammunition. That means you're not allowed to possess any of those things. Do you understand?
Yes, ma'am.
Do you have any questions about those terms?
No, ma'am.
All right. Thank you, sir. Good luck. Good afternoon. Please tell me your name.
Joy Lavender.
All right, you're here in 20 CF 12225, charged with false imprisonment and battery domestic violence. I see that you completed the application for the public defender's office. I'll appoint them to represent you. I do find that probable cause exists. Does she qualify for pretrial release?
She does, Your Honor.
She has a victim.
We have a victim present as well.
Oh. Yes, thank you for drawing my attention. Ma'am, can you please tell me your name?
Faith Powell.
I can't hear you. You have to get close to the microphone.
Faith Powell.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, does the state wish to inquire?
Yes, Your Honor. Ms. Powell, what's your relationship with the defendant?
She's been my girlfriend for almost 4 years.
And do you guys live together?
We did. I moved out yesterday.
Okay, so you have a separate residence?
Yes, I will not be in the residence with her.
And has anything similar to this happened in the past?
It has, but never to this extent, and the police have never been involved.
If the defendant got out today, would you be afraid?
No.
If she got out today, would you want contact with her?
I don't care. I won't be there. I mean, like, she don't have family or anything here, so if she needs something and she doesn't have a way to get it, then I'm willing to help. But as far as anything else, then no, not really.
And was there any alcohol or drugs involved?
No.
Yesterday? I have no further questions, Your Honor.
Defense?
No questions.
Just to clarify, ma'am, I can order her to have no contact with you at all, or only peaceful contact?
Only peaceful contact.
All right,
please.
that's what you'd like?
Yes.
All right, and you said she does qualify for PTR?
Yes, Judge.
All right, so ma'am, I'm going to place you on pretrial release with special conditions that you have only peaceful contact with the victim. That means you're not allowed to yell, raise your voice, throw things, anything like that. Do you understand?
Yes, ma'am.
All right, so no hostile contact, peaceful only. You're not allowed, She's allowed to return to the residence. You're not living there any longer?
No, I'm not there.
All right, so I'm going to order
I only
that-
need to return to get the rest of my things, but that's it.
All right, I'm going to order that you maintain separate residences because it's her residence now and you're coming back to get your things. You can arrange to do that together peacefully. So no hostile contact about getting the items. Do you understand?
Yes, ma'am.
All right. You're not allowed to possess firearms, ammunition, or weapons of any kind. Do you have any questions for me?
No, ma'am.
All right, good luck. Thank you, ma'am, for coming. Good luck. Good afternoon. Please tell me your name.
Pedro Luis Marine Escobar.
All right, you're here in 2020 CF 12210AO. You're charged with aggravated battery on a pregnant person. I see you completed the affidavit. For the public defender, I will appoint them to represent you. I find that there is probable cause for this arrest.
Who qualifies, Judge?
You qualify for pretrial release. Was the victim contacted?
Victim contact was made. According to the notes indicated, the defendant advised that they plan to attend initial appearance.
We don't have a victim in this case? All right. Special conditions of pretrial release will be that you're not allowed to have any contact with the victim. That means not through phone, social media, email, no contact at all. Not even through a third party. Do you understand? You have to answer out loud.
Yes, ma'am.
All right. You're not allowed to return to the scene of the incident except one time with law enforcement to gather belongings if you need to do that. You're not allowed to possess firearms, ammunition, or weapons of any kind. Do you understand?
Yes, ma'am.
All right. Do you have any questions for me?
No.
No? Okay. All right. Thank you. Good luck, sir.
Go straight TR, Judge.
Yes. All right. Please tell me your name, sir.
Jamar Onfroy.
You're here in 2020 CF 12198AO, charged with battery, domestic violence, and carrying a concealed firearm. I'll appoint the public defender to represent you. I find that probable cause does exist for this arrest. Is the victim here? All right. Does he qualify for pretrial release?
Judge, we weren't able to verify any of his information through any of the resources, and we weren't able to get in touch with the victim or his emergency contact.
All right, I'm going to set your bond and count one at $500. I'll leave the bond on carrying a concealed firearm at $2,500. You're not allowed to have any contact with the victim at all. You're not allowed to return to the scene of this incident. You're not allowed to possess firearms, ammunition, or weapons of any kind. Do you understand?
Yes, ma'am.
So if you have a firearm, you have to surrender that to law enforcement. Do you understand?
Yes, ma'am.
I'll give him 24 hours. Was there any allegation of drugs or alcohol involved in this incident? I don't believe so.
I didn't see any, Your Honor, to my recollection.
All right. All right, that's it. Thank you, sir. Good luck. Good afternoon. Please tell me your name.
Xavier Rivera.
Sir, you're here in 2020 CF 12226, charged with false imprisonment and battery domestic violence. I'll appoint the public defender to represent you. I find that there is probable cause. Do we have a victim here?
No, you don't.
All right. Does this qualify for pretrial release?
Judge, he was not qualified for pretrial release due to having an open case in Hillsborough County for kidnapping, battery by strangulation, and simple battery.
All right. Then at this time, sir, I'm going to set your bond on count one at $5,000. On count two, it's going to be $1,000. You're not allowed to have any contact with your victim for any reason. Do you understand?
Yes, ma'am.
That includes third-party contact. You're not allowed to return to the scene. You're not allowed to possess or consume alcohol or drugs without a valid prescription. And you're not allowed to possess weapons of any kind, and that includes firearms and ammunition. Do you understand that?
Yes, ma'am.
Was there something you did on this?
It was, no investigation, no weapons, no drugs.
No contact.
And
And no alcohol.
No alcohol. How much was the bond?
$5,000 on count 1 and $1,000 on count 2. All right. Thank you, sir. Good luck. Good afternoon. Please tell me your name.
Sean Stack.
All right, sir, you're here in 20 CF 12227, charged with tampering with a witness to hinder communication to law enforcement and battery domestic violence. Sir, I think based on the amount of money you make, you don't qualify for the assistance of a public defender. I'm not going to appoint them at this time. I do find that there's probable cause. Have we heard from the victim in this case?
We did make contact with the victim, Judge. They were undecided about coming to court today, but they did indicate that they wish to have no contact.
All right. I'm going to set your bond at $2,500 on count 1, $1,000 on count 2. You're not allowed to have any contact with your victim. That includes third-party contact. Do you understand?
Yes, ma'am.
You're not allowed to return to the scene of this incident. You're not allowed to drink or possess alcohol or drugs without a legal prescription. You're not allowed to possess weapons of any kind, including firearms and ammunition. Do you understand?
Yes, ma'am.
All right. Thank you, sir. Good luck.
Judge, for the record, he does qualify.
All right. I'll place him on pretrial release with all of those same conditions. So, sir, I'm changing your release conditions. Instead of a bond, I'm placing you on pretrial release. Do you understand?
What does that mean?
So you don't have to post a monetary bond, but you have to comply with all the conditions I just stated, and you'll have to check in with pretrial release. They're gonna tell you how often you have to call them.
Okay.
And let's do random drug and alcohol screens for him. All right, do you understand, sir?
Yes, ma'am.
All right, still no contact with the victim in any way. All right, thank you. Good afternoon, please tell me your name.
Pedro Castro.
All right, sir, you're here in 20 MM 733780. You're charged with battery domestic violence. I'm going to appoint the public defender to represent you. I find that there is probable cause here. Have we heard from the victim?
We did not make contact, Judge. A voicemail was left. He qualifies for pretrial supervision.
All right, I'm going to place you on pretrial release, sir. You're not allowed to return to the scene of this incident. You're not allowed to have any contact with your victim, including third-party contact. Do you understand?
Yes, ma'am.
You're not allowed to possess or consume drugs without a lawful prescription. You're not allowed to possess firearms, ammunition, or weapons of any kind.
Yes, ma'am.
You understand?
Yes, ma'am.
Do you have any questions?
No, ma'am.
All right, good luck, sir.
Thank you.
Good morning. Please tell me your name.
Yes, Cynthia Cicchetti.
All right. You're here in 20 MM 734380. I find that you qualify for the public defender. I'll appoint them to represent you. Oh, sorry. Does the public defender have any motions to make in this case?
Your Honor, we'd like to challenge the probable cause in this case. Based on the allegations, the officer was never given testimony that that Ms. Chinetti had ever actually hit the alleged victim in this case. He got various testimony, and in fact, the one witness that did testify said the opposite happened, that the alleged victim struck Ms. Chinetti. There's no testimony specifically towards her being struck, or her striking anyone.
State of Florida, have a response.
Yes, Your Honor. Yes, with this, they came in, once they were in contact, the call gave to reasonable suspicion to follow up on the Florida tag. When they went to, when the law enforcement officer arrived at the registered address, we came in contact with the defendant and the victim. The victim was pretty uncooperative, but was explaining a story that corroborated with the witness's story, minus the fact like that there was an interaction going on, that when there was visible injuries on the victim's face, there were scratches, there was, where is it? I'm sorry. Like recent information showed recent injuries to the right side of his face. The witness was stating that he was the driver. The defendant, or the victim, was the driver. The defendant was on the passenger side. So that's where the right side of the face would have been. They kept going. When they interacted with the defendant, she was intoxicated and cooperative as well and didn't provide a statement. I believe this reaches to the level of probable cause to go along with an interaction between the two in the car where the injuries were at and the intoxication.
So let me ask you, State, where's the nexus between the injuries and what caused the injuries? Because I agree with you, there are injuries to the victim here, but point me to the information that ties the injuries to the defendant. I see an anonymous caller witnessed a male hitting a female,
Yes, Your Honor.
and that the victim was uncooperative and kept telling the same story over and over again and showed recent injuries on his face caused by Cynthia. Is that the probable cause?
Yes. John kept repeating the same information and showed recent injuries to the right side of his face caused by Cynthia. That's yes.
All right, I appreciate the challenge, but I'm going to find, based on the statement that the injuries to the right side of his face were caused by Cynthia, that is at least probable cause in this case.
Your Honor, can I just briefly respond to that?
Yes, just get close to the microphone so I can hear you.
The one point where I believe it's in the arrest affidavit where it says that, I don't believe that is from testimony from the alleged victim. I believe that's just an inference made by the officer.
All right, so I don't know what your belief is based on. I can only read the words. It says John kept repeating, so that would be the victim stating, repeating the same information and showed recent injuries to the right side of his face caused by Cynthia. So John kept repeating would I think be the probable cause that John stated that the injuries were caused by Cynthia.
Okay. I just read it that he never specifically stated that, but he was kept stating, they had an argument or something.
I'm going to find probable cause. I understand your argument, but I think that statement that John kept repeating the same information and the end of that sentence, the injuries were caused by Cynthia, I think that's probable cause. Does she qualify for pretrial release?
We were not able to verify her community ties, Judge.
All right. I'm gonna set your bond, ma'am, at $100. You're not allowed to have any contact with the victim. You're not allowed to possess or consume alcohol. You're not allowed to return to the scene. And you're not allowed to possess weapons, firearms, or ammunition. Do you understand?
Yes.
All right, thank you, ma'am. Good luck.
Thank you.
Good afternoon. Please tell me your name.
Rodney Keys.
Sir, you're here in 20 MM 254E, charged with criminal mischief. I find that there is probable cause in this case. I don't have an affidavit for the public defender. Do you have an attorney to represent you, sir?
I will if I need to go to court.
All right, so this is your first appearance. I'm finding that there's probable cause in this case. I don't know if the state is going to file these charges or not, but at this time, you're not asking me to appoint the public defender, right?
No, when you say probable cause, are you saying probable cause from her side or from my side?
What I'm saying is, based on the affidavit written by the police officer, I find that there's probable cause to believe that you committed this offense.
Okay.
Probable cause is not proof beyond all reasonable doubt, and it does not mean that you're guilty.
Okay.
It just means there's probable cause in this affidavit.
Okay.
Now, the state has the responsibility to make a charging decision. I don't know if they're going to do that. They might look at this and decide it doesn't rise to that level, but that's up to the state. Does he qualify for pretrial release?
No, Judge.
All right, sir, I'm going to set your bond at the criminal mischief. Where? Just a moment, sir.
No, it's just in the wrong place. Okay.
I'm sorry,
That's okay.
You have no contact order, but it's not a DV.
I am going to order no contact.
It was classified
As a condition of bond, you're not allowed to have any contact with the victim.
According to the affidavit, it's the no contact is not, the domestic part is not marked. But if the judge want me to do a no contact order, let me do a no contact order.
Yeah, because this is a criminal mischief, so it doesn't matter the relationship between them. He's not allowed to have any contact. Do you understand, sir?
Yes.
That includes third-party contact, social media, no contact at all.
Mm-hmm.
All right. I'm going to set your bond at $250. And no contact. All right, do you have any questions?
Is there anything called a ROR?
Yes, it's called released on your own recognizance. I'm not inclined to do that.
Okay.
So it's just no contact on the only condition?
Yes.
Appreciate you.
Yes, sir. Good luck. Good afternoon. Please tell me your name.
Moise Lamage.
I'm sorry, one more time.
Moise Lamage.
Thank you, sir. You're here on 20 MM 509A charged with violation of a condition of pretrial release in a domestic violence case. And it looks like you have an open battery.
Yes, ma'am.
I'm going to revoke your bond on the open battery case. I will appoint the public defender to represent you. And I do find probable cause.
Your Honor, may I please say something?
I'm having trouble hearing you. You have to get closer to the microphone. But before you say anything, let me advise you that everything you say this morning is on the record and can be used against you in a later court proceeding. So it's probably in your best interest not to talk about the facts of this violation. Do you understand?
Yes.
Do you still want to say something?
Yes.
Go ahead.
The reason I went to the house.
So, sir, I'm going to stop you right there.
Okay.
Listen to what I'm saying to you. It's not that I don't want to listen to you. You have a right to speak, but you also have the right to remain silent. and the attorney standing next to you is telling you it's not in your best interest to talk about this. If you'd make admissions on the record, the state of Florida can pull this recording and use it against you later to prove your guilt. Do you understand?
Yes.
Okay, I just want to make sure you understand that. So in this case, state of Florida, is he entitled to bond on a violation of a condition of pretrial release?
I was looking that up, Your Honor.
I can't hear you at all.
Said I was looking that up, Your Honor, in the bond schedule as well. I believe he is.
I believe he is.
I believe he is on this one, and we did revoke the one on the battery case, though. Correct.
All right, I'll set his bond then at $1,000 on the violation of a condition of pretrial release. No victim contact for any reason. Do you understand?
Yes.
None. You're not allowed to have any contact.
Yes. I have 2 children. They have their school supplies and musical instrument. And my work uniform, my car is all there. May I please go get it?
I'll allow you to return to the scene one time with law enforcement, but I have to also advise you, I revoked your bond on the open battery case, so right now you're not going to get out of jail. It'll be up to your attorney to file a motion to be heard in front of the other judge, okay? But when you do bond out, I'll allow you to return one time with law enforcement. Okay. Thank you, sir. Good luck. Right. Good afternoon. Please tell me your name.
Bruce Francis Bland.
I'm sorry?
Bruce Francis Bland.
All right, sir. You're here today charged in 20 CF 12218, possession of methamphetamine. I'm going to appoint the public defender to represent you. I do find that there's probable cause here. I'm going to revoke your bond on your open case and set your bond at $1,000 on the new case.
He had 2 cases.
Okay, I'm revoking it in both of those. All right. Sir, do you have any questions?
My boss was supposed to have bond me. Was supposed to be coming to bond me out. So
I can't hear you. I'm sorry. You have to get really close. Leave the mask on. Just get close to the microphone.
my boss was. I had called my boss yesterday for him to bond me out, but I don't.
So you have a bond in this case, but I revoked your bond in your 2 open cases, so you won't be able to bond out right now. Your attorney will have to file a motion in front of the judge who's hearing those cases.
Okay.
All right? Good luck, sir.
Okay.
Please tell me your name.
Carol Casado.
I'm sorry?
Carol Casado.
All right, you're here in, looks like 2 cases. 20 CF 83AO and 20 CF 12202AO. You're charged with 3 counts of violation of a condition of pretrial release, possession of heroin, possession of cocaine, possession of drug paraphernalia. I'll appoint the public defender to represent you. All right, I do find probable cause exists. These are both new cases, right? She's not out on bond on any of them?
Judge, one's a warrant. The violation of condition of pretrial release was a warrant.
Yes.
But it's for a different case, possession of cocaine, not this possession of heroin and cocaine, right?
Yeah, they're 2 different cases.
Okay, all right.
One is a warrant and one is a new charge, yes.
All right, so on the warrant, the affidavit of violation of pretrial release, I'll revoke the pretrial release. Is she entitled to bond on those?
Yeah, I think that on the warrant, on the DOP, the judge,
Already put those,
yeah, if you.
I'm gonna leave the bonds as set on that warrant. That's fine, I'm gonna leave them.
Okay. Yeah, right.
Okay, so I'm leaving those bonds as set. In the 12202AO, I find probable cause. And I'll leave those bonds at $1,000 on count 1, $150 on count 2, and $100 on count 3. Do you have any questions?
No.
I'm sorry, I couldn't hear you.
No.
All right, thank you. Good luck. All right. In 20 CF 92870, Mr. Culver refused to appear. There's a warrant. I'm not revisiting the probable cause in the warrant, and I'll leave the bond at $2,000. I don't know if he has a PD. Does the public defender represent Mr. Culver? All right, I'll appoint the public defender. Are you waiving his appearance?
Yes, Your Honor.
Okay. Please tell me your name, sir.
Tyler Dante, miss.
I'm sorry, one more time.
Tyler Dante.
What's your last name?
Lattimore.
All right. Sir, you're here on 2020 CF 12220AO. You're charged with possession of methamphetamine, and appoint the public defender to represent you. I'm going to revoke your bond on your open possession of cocaine case, and I'm going to leave your bond at the possession of methamphetamine at $1,000. Do you have any questions for me?
Oh, yes, I do.
What?
That wasn't mine. It wasn't on the ground. You can find anything on the ground, miss.
I'm sorry, sir. I'm having trouble understanding you with the microphone.
I'm trying to say, how they gonna charge something with me that ain't find nothing on me?
So at this time, all I'm saying is there is probable cause to believe that you did. The state has the charging decision. I don't know if they're actually going to file this charge. We're just at the stage of probable cause. But based on the police report, I do find that there's probable cause. Now, you're represented by the public defender's office, so they can file a motion on your behalf if they don't believe that there's sufficient evidence.
Okay.
All right?
Mm-hmm.
All right, good luck, sir. Good afternoon. Please tell me your name.
Rogelio Leon.
Judge, I believe we have victims present for this case.
All right. Sir, you're here in CF 12215AO and 2020 MM 7349. And appoint the public defender to represent you. You're charged with violation of a condition of pretrial release and tampering with a witness. Good afternoon. Can you please tell me your names?
My name is Jacob McKenna.
I can't hear you. You have to get right up to the mic.
Jacob McKenna.
All right.
Jennifer McKenna.
Can you please raise your right hands to be sworn? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
All right. Does the state wish to inquire?
Yes, Your Honor. Mr. and Mrs. McKenna, or just let the court be aware that there is an open case. It's 20 CF 11128. That's where the violation of condition of pretrial release comes from. Also, this new charge, tampering with a witness, arises out of that.
Yes. Thank you.
All right, Mr. and Mrs. McKenna, can you explain just one at a time what happened yesterday?
We heard screaming and shouting in our backyard. My wife began to film, to take recording. He's screaming. He's saying he was going to harm my family, threatening to rape the original arresting officer, threatening to rape my wife from the backyard. He also was saying, I'm not on your property, but I'm going to keep, pardon my language, fucking with you. He went on and on. These videos went on for about 15 minutes, I think. I called the police. The police came out to go and try to apprehend him for violating the no contact order. His brother said he wasn't there. Then the police left. At that moment, Mr. Leon came out of the house or out off the side of the house or something, and then walked in front of my home. I noticed him, so I tried to rush outside to put my camera back up. And he saw me. He approached me. I told him to stop. He wouldn't stop. He said that him and his boys were going to take care of me. He had an object in his hand. I'm not sure what it was, but he kept holding it to his side and behind his back. I told him to stop again. He wouldn't stop, so I pulled out my pistol. He continued to approach. I fired. He took off. My wife pulled up in her vehicle, and at that point he was down on the corner. And at that point, when she pulled her vehicle up, he turned around and started walking back towards her in the vehicle. So I went back out and walked towards my wife in her vehicle, and he took off then again. At that point, I called the officers back, and they came and apprehended Mr. Leon.
And if the defendant got out today, would you be in fear?
Yes, very much so. Many times he has threatened the lives of my three little children. He's threatened the lives of the life of my wife and myself. He's threatened my dogs. He's threatened to rape my wife multiple times. I definitely don't want to. I don't want to see him out.
Thank you. I have no further questions, Your Honor. Just statements to the court after.
All right, does the defense wish to inquire?
No, Your Honor.
All right. Mr. Leon, I see that you raised your hand. Do you have
Yes,
something
ma'am.
you'd like to say?
Can I talk to him for just a second?
I understand. I'm most likely going to be stuck in here for a little while, and we'll just in the future we'll see whatever footage they have of me doing. It's what happened. Whatever they're saying that I did, and they don't have camera or footage, because I heard from the officer yesterday that they had surveillance of all around their house. So we need to see that surveillance from the original charges that were put on me. And that's why I was upset yesterday and all this happened. And I'm still upset. I didn't have my medication. And there's a lot of reasons why I'm upset, especially at the original charges that they put on me. And I'm fine. I'm willing to sit in here, cool down and think it over and until I talk to my public defender, we get the evidence that they have, because they are lying. Not once did I go in their house. Not once.
All right, sir, thank you.
And even what they're saying that I said, a bunch of that is not true.
All right, sir. So at this time, I'm going to revoke your bond
That's
on
fine.
the open
That's
case.
fine, Your Honor.
So for these two, wait, it's on here. No. So on the tampering with a witness charge, I'm going to put your bond at $25,000. If you are not allowed to have any contact with the victims.
That's fine.
No third-party contact, no
Mhm.
social media, no telephone, no in-person. Do you understand?
Yes, ma'am.
All right. You are not allowed to return to their house. I understand it sounds like you live behind their house.
My brother lives behind their house pretty much.
Your
we're their
brother
neighbors.
lives behind their house?
Yeah.
All right, so
And-
you have no business being at your brother's house either. You can't be anywhere near their residence. Do you understand?
That's fine.
All right.
That's fine.
It's not in your best interest to be at your brother's house where they
Yeah,
can
no,
see you.
I'm seeing that. I'm starting to, I realize that
So
now.
don't go to your brother's house.
I will not. I will
Yes,
not.
sir, did you want to say something else?
I spoke with the family yesterday. He said that they were just doing a favor and letting him crash there a few days or something because he had gotten into a fight with his mother. They stated to me they really didn't care for him being there. They were just doing a favor for his mom, and that they don't expect him to return.
All right, well, I'm ordering you not to return.
That's fine. That's fine.
And this court doesn't have jurisdiction over your brother, but it has jurisdiction over your behavior.
No,
so
well,
you
I-
cannot
yeah,
return.
Me naturally, me and my, for my own good too, I don't want to be around.
I think that's a wise decision.
Yeah.
Yes, sir.
Your Honor, just to clarify, just for the record and everything, can we just make it like a feet, like come within 1,000 feet of the
Okay.
residences?
Let's say that. You're not allowed to be within 1,000 feet of their residence.
Of the residents. Okay, that's fine.
You're not allowed to have any contact with them. And in the 20 MM 7349 violation of condition of pretrial release, I'm going to set your bond in that case at $1,000. Same conditions, you're not allowed to have any contact with the victim, and you're not allowed to be within 1,000 feet of their house. Do you understand, sir?
Yes, that's fine.
All right. Good luck, sir.
All right.
Thank you for coming.
Your Honor, can we also add the additional term of no weapons?
Oh, I'm sorry. I should have said that. You're not allowed to possess weapons of any kind.
I don't believe in guns.
Okay,
Your Honor, I
but-
don't like guns. I've never had them. I don't, my record shows that. I've never had a gun
Okay,
charge. I
but
don't
this
like
is
guns.
weapons of any kind.
Okay, that's
Not just guns.
Well,
And I'm
sometimes I
glad you
carry
don't
a
have a
razor
gun.
knife because that's my type of work that I do. I'm a painter, I do, so sometimes I have a razor knife on me at all times, but.
You can't have that right now. No razors, no knives, no
Not even at work?
machetes.
Like if I'm outside, if I'm out free at work, I can't have no razor knife on me?
How big is this razor?
It's just a box cutter. I'm a painter.
That's also a weapon, sir. No, at this time you can't have a box cutter.
Okay.
While you're out on bond, you can't.
Okay.
All right. Good luck, sir. Thank you very much for attending.
You're welcome. Thank you.
Good luck. Good afternoon. Please tell me your name.
Kenneth McCaskill.
All right, sir, you're here in 2020 CF 122130, charged with robbery. I'm going to appoint the public defender to represent you. I do find there's probable cause in this case. Wait, does he have two cases?
Yes, Judge.
I'm sorry. 2020 CF 12212AO, also attempted robbery with a mask. I find that there's probable cause in both of these cases. Does the state wish to be heard on bond?
No, Your Honor, I would just defer to the court.
All right. Sir, I'm going to set your bond in case number 20 CF 12212AO. Actually, it's already set at $5,000. I'm going to leave that. And in 2020 CF 12213AO, it's also set at $5,000. I'll leave that. You're not allowed to return to the scene of either, and you're not allowed to have contact with either victim. You're also not allowed to possess weapons of any kind. Do you understand?
Yes, ma'am.
All right. Good luck, sir. Good afternoon. Please tell me your name.
Jacob McLemore.
All right, you're here today in 20 CF 12221AO, charged with possession of methamphetamine. And Seminole County case 1702723, a violation of probation. I'm not going to disturb the warrant in that case. That's set at no bond. I find there is probable cause in the possession of methamphetamine case. I'll leave your bond set at $1,000. And I'll appoint the public defender to represent him.
The on you in Seminole County, you filed this in, leaving it at no back?
Correct. All right, sir. Do you understand?
Yes, ma'am.
All right. Good luck, sir. Thank you. Good afternoon. Please tell me your name.
Peterson Theo.
I'm Peterson Theo.
Theo Peterson.
Oh, Theo Peterson. Okay. Sir, you're here in 2020 CF 1220780. I'm going to appoint the public defender to represent you. You're charged with aggravated battery on a person over 65 years old with a deadly weapon. Does the state have a probable cause affidavit in this case?
I believe it's probably the same one you have. The subject did strike victim on his left hand with thrown mailbox, causing bodily injury.
All right.
And Your Honor, in this case, the defense is objecting that there's no probable cause in this case. There's not a statement of what happened at all. What the arrest affidavit says is it's subject. I don't know who the subject is. It's a fairly poorly written affidavit. We don't really know what happened at all.
State?
The state would just be asking for a 24-hour reset to reach out to the officers, to have them write a supplemental report. To
All
provide
right. I'll give you
more.
24 hours. Sir, I'm going to give the state 24 hours to get a more detailed police report, but you'll be back tomorrow morning to see another judge. It won't be me here tomorrow. And I imagine that if the state doesn't have more information, something is going to happen with your case tomorrow. All right? Good luck, sir. Good afternoon. Please tell me your name.
Jean-Nic St. Fleur.
All right, you're here today. Hold on. Yes. In 2020 CF 1220880, charged with battery on a law enforcement officer, resisting with violence and resisting without violence. You also have several open cases. Is he out on bond on all of these?
Out on bond on 27 cases, Judge.
All right, sir, you're out on bond in 27 cases. I'm going to revoke your bond in all of your open cases. I do find there's probable cause here. I'll appoint the public defender to represent you. Let me ask, the public defender, you don't have a probable cause challenge in this case, right?
No, Your Honor.
All right. I already found probable cause. And I'm going to leave your bonds at $2,500 for count one. But I'm going to set $1,000 on count two and $100 on count three. But at this time, I've revoked your bond on the other 27 cases. So you want to wait to post that other bond until you talk to your attorney. Do you understand? Your attorney will file a motion in front of the other judge. All right, thank you, sir. Good luck. Next. Please tell me your name.
Jennifer Silva.
You're here in 20 CF 12231. You're charged with trafficking in cocaine, possession of a concealed weapon, possession of drug paraphernalia, 2 counts, and possession of cannabis. Do you have an attorney to represent you?
Yeah.
You have to answer out loud?
Yes.
All right, so I'm not going to appoint the public defender to represent you. I do find that probable cause exists. on count 1, does the state wish to be heard on bond?
No, Your Honor, we defer to the court on this.
Give me one moment. All right, I'm gonna set your bond on count 1 at $50,000. Oh, I'm sorry, $200,000. There's a firearm. So your bond on count 1 is $200,000. Count 2 is $1,000. Counts 3 and 4 are each $500, and count 5 is $250. Good luck, ma'am. Yes. Next, please tell me your name.
Annette Marguerite Stallman.
All right, ma'am. You're here in case number 20 CF 1220980, charged with grand theft of a motor vehicle. I'm going to appoint the public defender to represent you. I find there is probable cause. I'm going to revoke your bond on your open cases and set your bond in this case at $1,000. You're not allowed to have any contact with the victim. Do you understand?
Yes, ma'am. Your Honor, may I say something pretty please? I just got out on the 6th. The same charge was dropped. And I reposted, I just got out on the 6th, like 5 days ago. I'm trying to get my life together and this happened again. I mean, I don't know what's going on. I don't even know how this can happen. It was my car. The only reason why it was in his name, so I could go back and forth to work. I finally got a job. Is because he had the good credit. But the charges were dismissed. I had to rebond out, and I got out on the 6th, and it's the 11th now. I mean,
I don't know what charges were dismissed. She does have
the
an open
grand theft
case.
auto, the same thing, same charge, same car, same everything.
No, I'm not talking about that case. You have an open case for delivery of cocaine and possession of cocaine.
Yeah, no, this happened back in January.
Okay, so in the cocaine case that you're out on bond, I'm revoking that bond. But
No,
on the
I
grand
know.
theft case, I am giving you a bond. But
No.
first, you have to see the judge who first gave you the
This is
bond
what
on
I'm
the
talking
cocaine.
about, the GTA. This is what I just got arrested for.
Right, but at this time, based on the probable cause affidavit, there is probable cause to believe that you committed grand theft. I'm not
I did.
suggesting that can be proven by up to a jury, and I'm not suggesting the state is going to file that charge. That's up to the state.
Yes,
So
ma'am.
you have a public defender representing you, and they can make those arguments with the state. And then they can also file a motion for bond with the judge who gave you the original bond.
Yes, ma'am.
All right, so they'll address that at a later time.
Yes, ma'am.
All right, thank you, ma'am, good luck.
Okay, thank you.
Yes. Please tell me your name.
Philip Starnigger.
I'm sorry?
Philip Starnigger.
All right, sir. You're here in case number 20 CF 12232.
What about it?
Your charge is first-degree murder with a firearm. Sir, do you have an attorney to represent you?
Yeah.
I'm sorry, I can't hear you.
Yes.
Please get closer to the mic.
Yes.
All right, so you don't want me to appoint the public defender for you?
No.
All right. Does the state wish to be heard on proof evident presumption great?
Your Honor, may you give me a second? I was under the impression that this was a warrant.
This is a warrant.
I don't have the warrant in front of me. I just have the arrest affidavit stating that it's a warrant. So if I could just defer to the court.
Are you
on this.
asking the
We'd be
court
asking for
to,
no bond. And-
are you asking the court to review the affidavit and make a determination based on that information?
Yes, Your Honor, I don't have any of the information.
All right. At this time, sir, I'm going to find that based on the information contained in the affidavit, the state has met their burden. The proof is evident and the presumption is great here. Now, I understand that your defense attorney is not here today, so they'll probably file a motion and preserve the right to have an Arthur hearing downtown in front of another judge. This is just the determination here at initial appearances. So based on my determination that I just made, I am going to hold you without bond at this time. Do you understand?
Yeah.
I'm sorry?
Yes.
All right, you'll want to get in touch with your attorney right away. All right, let's take a brief recess. Be in recess for 5 minutes. We are back on the record. Good afternoon. Please tell me your name.
Moises Urino.
I'm sorry, what?
Moises Urino.
All right, sir. You're here in 20 CF 12199AO, charged with reckless driving and fleeing or attempting to elude.
Qualifies judge.
All right, I'm going to appoint the public defender to represent you. I do find there's probable cause. Qualify for pretrial release. I'll place you on pretrial release. Does the state wish to be heard on bond versus pretrial release?
Yes, Your Honor, just with the facts showing the fleeing, eluding police with disregard the safety towards the community, the state would be asking for an appropriate bond instead of pretrial release.
What's appropriate, state?
On that one, would be asked for a $5,000 bond set for count 2, Your Honor.
It's an F2, is that what you said? Or count 2?
Count 2, yes.
All right, sir. I'm inclined to follow the recommendation of the state. I'll leave count 1, the reckless driving bond, at $500. I'm going to make count 2 bond $5,000. And I did appoint the public defender, right? All right. Do you have any questions, sir?
No, ma'am.
All right. Good luck, sir. Why do I have so many things to sign now? Oh, that's why. Oh. Sir, please tell me your name.
Jamar West.
Jamar West. Got it. I got it. You're here in 20 CF 12201. AO, charged with battery on a law enforcement officer. But in these other cases, he is out on bond?
Yes, Judge.
So it's just this one, that the misdemeanor was consolidated into felonies?
The traffic case that we discussed was the only one that was in question.
All right.
The 18CT?
Yes.
73?
Sir, do you have an attorney to represent you?
Yes, ma'am.
All right, so you don't need me to appoint the public defender to represent you, right?
No, ma'am.
All right, in 12201AO, I do find that there's probable cause to believe you committed battery on a law enforcement officer. I'm going to revoke your bond on your open cases, and in this case, I'll set your bond at $2,500.
You revoking the other bonds?
Yes, sir. So your open cases that you're out on bond, I'm revoking those bonds. So your attorney will need to file a motion in front of the judge who's hearing those cases.
Even the traffic case? Are you
Except the traffic case.
taking no action on that one, but the other two
Correct.
felonies?
In 2018 CT 7342AO, I'm taking no action.
The other two, you
Right.
So on two charges are revoking on bond?
2 cases,
2 cases?
but they might have more than 2 charge. They might have more than 1 charge each.
Okay.
All right, so your attorney will have to file a motion, sir. All right, good luck. Thank you.
That was 2,500 and the other stated no bond, correct?
Yes,
Except for the traffic was no action.
except the traffic, no action, right. They need to sort that out downtown. Good afternoon, sir. Please tell me your name.
Eddie Javon Williams.
All right, Mr. Williams, you're here in 2020 CF 12222AO, charged with aggravated assault with a deadly weapon and battery. Sir, I'm going to appoint the public defender to represent you. I do find that there's probable cause. Is there a victim here?
No.
No. Does he qualify for pretrial release?
He declined to speak with pretrial judge.
All right. Does the public defender wish to confer with his client? What?
Your Honor, Mr. Williams would like to confer with.
I can't hear you.
I'm sorry. Mr. Williams would like to confer with pretrial release about the possibility of having that.
All right. So what I'm going to do is, Mr. Williams, I'm going to set a monetary bond, or in the alternative, I'm going to place you on pretrial release if you qualify. So you'll interview with pretrial release, and if you do qualify, then that will be your conditions of release.
Okay.
In either, whether it's a monetary bond or pretrial release, you're not allowed to have any contact with the victim. You're not allowed to return to the scene of this incident. Do you understand?
Yes, ma'am.
All right. You're not allowed to possess weapons of any kind, firearms, or ammunition. Do you understand?
Yes, ma'am.
You're not allowed to possess or consume alcohol or drugs without a valid prescription. If you're placed on pretrial release, if you qualify for that, they're going to do random drug and alcohol screens. So you can't drink any alcohol. Do you understand?
Yes, ma'am.
Okay. All right. Thank you, sir. Good luck.
Thank you.
Oh, the monetary bond is going to be $2,500 on count 1 and $100 on count 2.
Okay. Thank you.
Yes, sir. Good luck. Who? All right. Yeah, reset that tomorrow, please. Is the victim's not here in Bentley, right?
No.
Sir, tell me your name, please.
Maurice Cotton.
All right, sir. You're here today in 20 MM 7348 AO, charged with violation of domestic violence injunction.
Correct.
All right. I'm going to appoint the public defender to represent you. Ma'am, can you please raise your right hand? Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, please state your name.
Elizabeth Laris.
I can't hear you. You have to get close to the microphone.
Elizabeth Laris.
All right, does the state wish to inquire?
And this is this on Maurice Cotton?
Yes.
Yes.
Okay. Sorry, I was. Yes. All right, Miss. What's your relationship with the defendant?
He's the daughter of my 10-month-old daughter. We had a relationship for 2.5 years that ended in July.
Okay. And do you guys currently live together?
No.
If the defendant got out today, would you be afraid?
Yes.
And would you want any contact with the defendant?
No.
Has this ever happened before?
Yes. He hasn't been arrested for it before, but the injunction was put in place on the 29th, and he was at my residence this past Monday, and then at my residence again at a little past midnight on Wednesday morning.
All right. There's no more questions, Your Honor, from the state.
Does the defense wish to inquire?
No, Your Honor.
All right, sir, I see that you are also out on bond. I'm going to revoke your bond in that case. Is he entitled to a bond in the violation of domestic violence injunction order? State.
I can look into that, Your Honor.
Okay. Defense, do you know?
I'm sorry, Your Honor.
Is
was
he
the
entitled to bond on the violation of the domestic violence injunction?
Yes, Your Honor. Yes. He is entitled to a bond.
Yes, Your Honor, he is.
All right, sir. I'm going to set your bond in 20 MM 7348AO at $1,000. You're not allowed to have any contact for any reason with the victim. Do you understand?
Correct.
That includes third-party contact, social media, telephone, in person. No contact.
Okay. So how do I get to see my daughter?
I can't hear you. Get closer to the mic.
How do I actually get the chance to see my daughter?
Your attorney is going to have to file a motion in front of the judge who's hearing this case, but at this time, you can have no contact with her.
Okay.
You may not return to the scene. You're not allowed to possess weapons of any kind, which includes firearms or ammunition. Do you understand?
Okay.
Ma'am, was alcohol or drug use involved in this offense?
No.
All right. Do you have any questions? Do you understand the court's orders? All right, thank you, sir. Good luck. Thank you, ma'am, for coming. I have a whole stack of stuff for you. Please tell me your name, sir. What's your name?
Timothy Harris.
All right, you're here for a failure to appear in 20 CO 701AO. The bond is $500. I'm going to leave it there. Do you have an attorney, sir?
No.
Do you want me to consider appointing the public defender to represent you?
Yes.
Did he complete the affidavit? All right, I'll provisionally appoint the public defender, but you'll have to complete that affidavit. Do you have any questions, sir?
Yes.
What's your question?
Will I be able to get out today?
You have a bond, so if you can post the bond, then yes. There was a bond on the capias that was $500. I'm not disturbing that capias.
All right.
All right? Good luck, sir. I feel like as fast as I can sign it, you're stacking them back up. Please tell me your name, sir.
Anthony Santana. Good afternoon, Your Honor.
Good afternoon, sir. You're here today in 20 MM 3384AO. You're charged with a failure to appear.
Yes, ma'am.
There was a capias issued for your arrest with a $500 bond. I'm going to leave that. I also see that you have some open cases. One open case.
I did 97 days on this case, ma'am. This is an old case. What happened being on the streets until I spoke to my daughter yesterday, who's 19. I wasn't aware I was supposed to be in court on Tuesday. Now, the thing was that I had already signed a plea deal like a week before I bonded out. She bonded me out on the cases. And it was just never able to come in and see Mark LaCasio. I actually came in one day in person across the ways, and I seen Jared, my other attorney on the felony, Adelman, and Mark wasn't available because all it was, it said we could have done it on the TV screen, telephone, but being on the streets, or I was just going to come in, and I did walk into 4B one time, and that's Judge Hewitt, to do it, but the attorney wasn't there. Because all it is, I already signed the plea deal. It's credit time served for the 97 days that I did here in the county jail before I bonded out.
All right, sir. What I'm going to do is I'm not going to revoke your bond on the open case.
Thank you.
But you still have a $500 bond on this capias, and I'm not going to change that.
Okay.
So your attorneys will have to file motions in front of this judge, okay?
Yes, ma'am.
All right. Good luck, sir.
Okay. Thank you.
Yeah, it's all out of order. Good afternoon, sir. Please tell me your name.
Alan Sidney Oswald Edwards.
All right, sir. You're here in 20 CT 887AE, charged with driving while license suspended. I'll appoint the public defender to represent you. I do find probable cause exists. There is currently a bond of $500, and I'm going to leave that. Do you have any questions, sir?
Yes. My driver license was suspended for insurance, and
So before you say anything else, I just want to tell you everything you're saying here is being recorded.
Yes.
So you might not want to make any statements about the facts of the case. We're not deciding the facts of the case today.
okay. So I have a question. Okay. Am I going home or? I don't have no way to log out.
Your attorney, sir, can work with the state on your behalf, and he might be able to negotiate something based on why your driver's license was suspended, but we can't do that today.
Yes, I was wondering if I could get OR'd because of my job. If I lose my job, I won't be able to recover.
Hold on one second, sir.
The it's in my name and it's been impounded, so it'll be a hardship if I lose my job because I work for Cars for 1K Plus, and the only way I can contact my boss is in person. His
Okay,
phone
hold on.
number is. His phone number is.
I don't need his phone number. I'm not going to call him right now. Where do you work?
Cars for 1K Plus. It's on Edgewater Drive.
Does he qualify for pretrial release?
Judge, we weren't able to verify any of his information. He did tell us as well that he was working at Cars from 1K Plus for 1 week, but he was unable to provide any supervisor information or any information that would help us to verify the information that he had provided.
All right, sir, so here's what I'm going to do. I'm going to leave your monetary bond at $500, but I'm also going to say in the alternative, if he can qualify for pretrial release. So if you're able to give them more detailed information and they can verify your information, you might qualify for pretrial release, in which case you'll be able to get out without posting the monetary bond. Do you understand?
Yes.
Okay, so we'll do that in the alternative. All right, good luck, sir.
Were there any conditions, Judge?
No. Please tell me your name, sir.
My name is Francisco Luis Navarro, ma'am.
All right, good afternoon, sir. You're here in 20 CT 6320AO, charged with driving with a suspended license. I'm going to appoint the public defender to represent you. Wait. You're here in several cases. 20 MM 7338AO. Hold on. MM 7339AO. All right. Sir, I'm going to appoint the public defender to represent you.
Yes, ma'am.
And is that 20 CT 6320? Did I skip that one? No, I got that one first. Okay, I got it. All right. I do find probable cause exists for each of these cases, sir. Does he qualify for pretrial release?
No, Your Honor, he's on state probation.
And he's a violent felony offender of special concern?
Let me confirm that for you, Judge. I believe so. I just wanna-
But he doesn't have any felony cases right now, right?
It's the burglary with assault that would make him that.
But is that a conviction?
That's what he's on probation for.
That's what he's on probation for. All right. I don't have a VOP warrant here today, but since you're on felony probation, one will probably be pending.
Ma'am.
I'm going to leave your bonds, the monetary bonds, set as they are in these cases. So you have $500, $500, $500.
Yes,
And-
he is a VFOSC.
What?
He is a violent felony offender.
Right, okay. All right, then actually, I'm gonna change the bonds in resisting without. So in 20 MM 733880, I'm gonna raise that bond to $1,000, and 2020 MM 733980, I'm gonna raise that bond to $1,000. Sir, you wanna talk to your attorney about whether you should post bond or not. If you have an open violation of probation, there might be a warrant coming for
I
that.
understand that, ma'am. I just want to speak on one step, and I'll leave.
Okay, yes,
Yes,
I'll
ma'am.
listen. I'm happy to listen.
Yes,
Let me tell
ma'am.
you one thing before you speak.
Yes, ma'am.
Everything you say here is being
I
recorded
know.
and can be used against you.
And I absolutely understand
Okay,
that, ma'am.
all right. I just wanna be sure.
I just want to clear the fact is I just came out doing 5.5 years, and I've been out 2 years already since coming out of prison, ma'am.
Okay.
I ain't never got stopped or anything. My wife was sick, and I had to drive to Walmart, as you can see on the little thing. I had to drive to Walmart to pick up the food from Walmart. I did not get stopped by the police. They did not turn on no lights. I walked to the officer and asked him what is going on. When I walked up to the officer and asked him what was going on, he was like, because you're driving without a license, and cuffed me and locked me up. I didn't understand why. I really didn't understand why. Why was he following me? Because the car was under my wife's name, not under my name, Tara McCoy. So when that happened, boom, he handcuffed me, put me in the backseat of the car, really big, because I was just talking back to him. That was the only reason why. But come to find out, my PO was supposed to come to my house today, ma'am. To be honest with you, I did not do nothing wrong. He didn't turn on the lights behind me. He did not stop me like that. I was already pulled up with the app. You know, when you got the Walmart, when you order food from Walmart, you know, the app to reverse back. I was already parked. They were loading the food and everything. I chose to walk to the officer because I already felt something, because they've been following me everywhere. So when I walked up to the office and asked him that, he was like, oh, because you're driving without a license. How is that even possible that you even ran that car under that name with my wife's name on there and come up with my name on there? That's impossible.
I think there could be some things that your attorney might want to file on your behalf, but we can't address those today.
Yes, ma'am.
So
Yes,
I
ma'am.
understand what you're saying.
Yeah, okay, yes, ma'am.
Make sure that you say all that to your attorney.
Yes, ma'am.
So if he wants to file any motions, he can.
Yes,
And
ma'am.
also talk to him about whether you should bond out and whether there's a pending felony VOP.
The only thing I got right now, because they already bond out. I already paid for a bond, right? Boom.
On the VOP?
Yeah, no, not on the VOP, on this case. I already paid for it. They got a hold. Yes, they did. Moncrief, my wife did it. Trust me. Because of Moncrief. I went through Moncrief. The
Okay.
only reason why, because they got that hold on me. That's why I didn't get released last night. They kept on saying it and repeating it because they got that hold, that 5-day hold. So it give my probation officer time to basically
right.
to go ahead and violate me. But
so-
I've been on track. I've been paying all my probation and everything. It really wasn't. It didn't make sense. But
All right,
all
well,
right,
just
ma'am.
make sure you
appreciate
talk to your attorney before you do anything so that you're doing what's in your best interest, okay?
it. Yes, ma'am. I
All right,
appreciate
good
that,
luck.
ma'am.
You said it's going at 500 on the no valid, no
Correct.
special condition.
Right. No special conditions.
No, everything's good. So-
No special conditions, right.
Okay, yes, ma'am. Thank you.
All right, good luck, sir.
Yes, ma'am. You have a good day, ma'am.
You as well. Please tell me your name.
Franco Ponce.
All right, sir. You're here in 20 CT 1227AW, charged with DUI. Sir, based on the affidavit that you filled out, I don't think that you qualify for the appointment of the public defender. You have a job?
Yes, ma'am.
All right. Do you have an attorney representing you in your open battery case?
Yes, ma'am.
All right. I'm going to revoke your bond in the battery case. I'm going to find probable cause exists for the DUI charge. I'm going to leave your bond at $500 with a special condition. If you bond out, that you're not allowed to possess or consume any alcohol. I'm not appointing the public defender to represent you. Do you have any questions for me?
Do I have a bond? Yes.
You do have a bond, but I revoked your bond in the battery charge. So you'll have to talk to your attorney about that. They'll have to file a motion in front of that judge. It's an Osceola case.
So are they going to transfer me to Osceola or?
I don't know if we're transporting right now.
So that means that I have to stay?
I don't know if you'll stay here or are we transporting to Osceola?
started yet, but.
Okay, I'm not sure if you'll be
definitely no transfer
transported.
would start before locals had been satisfied.
Okay.
And Your Honor, on this, I'm not sure if I just didn't hear you. You said no alcohol, and was there no driving as well? I don't know if you.
Yes, you're not allowed to drive, sir.
Yes, but I'm saying, you said the bond is revoked, so that means I cannot pay the bond today?
Correct. You can pay the bond in the DUI case, but you can't pay the bond in the battery case. I revoked that bond. When you're out on bond in a criminal case and you pick up another criminal charge, oftentimes your bond gets revoked because one of the conditions of bond is while you're out on bond, you're not allowed to commit any new law violations. I find that there is probable cause you committed another crime while out on bond. So your attorney can file a motion in front of the other judge.
Okay, yeah, I don't have my lawyer number. There's any way I can get it? Call?
I don't have it.
Okay.
You'll have to look for it. All right, thank you, good luck.
Thank you.
Romligan bonded.
I'm sorry?
The next person was bonded, Romligan.
Okay. Oh, I don't have that person.
Okay.
Oh, no, I do have that person. I don't have their face sheet because you took it out already. Yeah.
Did they bond?
Yes. Good afternoon. Please tell me your name.
Joseph Fillion.
All right, sir. You're here in case number 20MM 733480, charged with retail petty theft. I'm going to appoint the public defender to represent you. I do find probable cause for this offense. I'm going to leave your bond at $250, but I'm going to revoke your bond in your open case. You have an open petty theft case? Actually, I have two. One's criminal mischief and one's petty theft. I'm revoking your bond in both of those cases, sir, so your attorney will have to file a motion in front of the judge who's hearing those cases, all right? Do you have any questions for me?
No, ma'am.
All right, good luck, sir. Good afternoon, sir. Please tell me your name.
Randy Freeman.
I'm sorry, did you say Randy Freeman?
Yes, ma'am.
All right, sir. You're here today in 2020 MM 734080 and 2020 306662. You have a warrant out of Volusia County for a failure to appear. The bond on that warrant is $100.
Appear for what?
Yes, sir. I'm sorry, what?
Failure to appear for what? I don't understand this.
Okay, hold on one second. Let me pull up the warrant.
Clear to appear on a trespass, Judge.
It's, but I don't know what court date he failed to appear. So you had a pending criminal charge for trespass on a property other than a structure, and you failed to appear for a court date in that case. So the judge issued a warrant for your arrest. But the judge put the bond on that at $100. So you have a bond. A lot of times on failure to appear cases, there is no bond. You actually have a bond, and I'm going to leave that. So you are able to bond out if you have that money.
I don't have no money on it.
I understand, sir. But because that's another judge's warrant, I can't change that bond. So it'll have to, the judge in Volusia County has to change that for you, okay?
So how this procedure go? They gonna take me to Volusia for this?
I don't know if we're transporting you to Volusia, but we have a judge here in Orange County who works with judges in other counties to see if they can resolve these cases. So she'll get this case tomorrow, and then she'll look at it and talk to the judge in the other county. And then on the possession of cannabis case, I do find that there's probable cause that you possessed cannabis. I'm going to, does he qualify for pretrial release?
No, Your Honor.
Your Honor.
Yes, sir.
The cannabis it wasn't enough cannabis to even roll. It was something that fell out or used one long time ago, man. It was crumb. And I don't see why I'm arrested for that, because actually I got a card. The smoke mill one. I got, but I can't go get it because I have to pay for it because the insurance is not covering it, so I don't get it. I just had crumbs in my pocket, man. And I thought it was a law that they gonna stop locking people up for small amounts like that. And I don't know why I'm even in front of you for such thing like that, Your Honor.
Well, sir, currently in the state of Florida, it is still a crime to possess marijuana like that. So that's why they arrested you on that. But because you had the out-of-county warrants, they would have arrested you anyway. So the warrants are the more serious crime that you'll need to face. Does the state have an offer should he want to plead guilty to the possession of cannabis this morning?
It'd probably be in his best interest.
I can't hear you.
It'd probably be in his best interest not to. Just let it go into our intake division.
I prefer to just resolve it, Your Honor.
I can give an offer if he would like to accept it. It'd just be a withholding court costs, or we can release him on ROR on this and let our intake division.
I'm not sure it's in his best interest for me to release him on ROR on
Yeah.
this while he's sitting in jail on a warrant.
But I just want to resolve it, because you're just over with, Your Honor.
If you'd like to resolve, just withholding court costs.
So here's the thing,
Best I
sir.
can do.
If you want to resolve the cannabis charge today, you can do that, but you're not going to get out of jail because you have the warrants out
You
of
said my
county.
bond was $100, John.
It is. So if you can post that bond in those cases, you can get out of jail.
But can you ROR me on that, though?
I can't. It's not my warrant. Another judge set that. So I can't change
Your
what the
Honor,
other judge
I'm
said.
over there on International Drive, and my checkout time was today, and I'm gonna lose a statue. It's important stuff to me, man.
I'm really sorry, sir. I can't change another judge's warrant. So if you, I don't think it's in his best interest for me to ROR him, Mr. Public Defender.
Miss,
Do you agree?
Your Honor,
Yes, Your Honor.
All right.
Right now, we'd have to resolve the other case.
Right. I can't do that today, but what we'll do is I'll leave a note for the judge who handles our out-of-county warrants and see if she can look at this tomorrow.
Tomorrow. But the cannabis charge, can we get that over with right now? I don't care what it is. I want to get it over with. I don't want you coming back and forth, taking care of no more and all.
So here's the other thing, though. The state of Florida might actually drop the cannabis charge. So if you enter a plea to that today, you can do that. And
Is
the
it
court
2
will give
days
you-
time, sir? My record already messed up, Your Honor. I don't care about it.
the court would give you 2 days credit time served.
Let's go.
But then if the state were to drop those charges at a later time, I
Miss,
can't.
I'm trying to resolve everything, and I'm trying to go home, man.
Okay.
And I don't care about the state holding nothing.
All right. Do you understand the rights you're giving up if you enter a plea of guilty today?
Yes, ma'am.
You understand you have the right to a jury trial, the right to remain silent, the right to call witnesses to testify on your behalf, and you're giving up all those rights if you enter a plea of guilty.
Yes, ma'am.
Okay. I'm going to accept your plea of guilty. I'm going to withhold adjudication. I'm going to order you to serve 2 days in jail, give you credit for the 2 days that you've served, and I have to order you to pay the court costs because I'm not allowed to waive those, all right? So you're going to have to pay court costs, and I'll give you a year to pay those.
Oh, Lord. Is that going towards my license?
It does if you don't pay them.
Oh, Jesus. I'm trying to get my license, man.
Right, but he's saying the court costs if he doesn't pay them.
I don't know about the court costs, but I know this one.
Yeah, it's not an adjudication of guilt. I'm not adjudicating you guilty. But he's talking about the court costs. He does have to pay them. I'll give you a year to pay it, so you have a whole year to get that paid. Or if you want to withdraw your plea and not plead guilty today and see if the state will drop those charges, you can do that.
When you gonna drop them tomorrow?
I don't drop them. That's up to the
No.
state.
When the state might travel on dropping it tomorrow?
I doubt it's going to be tomorrow. It's going to be within the next 33 days of.
Right.
If it
I'll
does.
take the 2 day time, sir, man.
All right. So that's my sentence.
You doing right?
And give him a year to pay the court costs. And I'm going to leave a note for Judge Carter.
What was your suggestion?
This one.
Okay, thanks, man. Now, tomorrow, on this resolution.
Let's go, sir.
All right, good luck, sir.
She said she was done. He's not even your public defender.
But he was telling me something very important in this matter, though. Your Honor. No, I'm not trying to be disrespectful, but this is very important stuff he telling me.
Contact you about the case later, okay? Once we have an offer and what's going on, okay?
I think that case is over with anyway. Can you look into that?
I can't do that. Somebody will contact you.
Thank you.
All right, good luck, sir. Good afternoon. Please tell me your name.
Hi, ma'am. My name's Shaquanda Lockhart.
You're here in 2020 MM 73328O, charged with criminal mischief. No,
Get-
I did not.
You
give
say
that yet.
get. Oh.
I was going to leave a note for the
Right,
judge,
huh?
and just haven't written it. All right, I'm going to appoint the public defender to represent you. I do find probable cause exists in this case.
Your Honor, we would like to challenge that.
All right, go ahead. Sorry.
The amount of damage is never alleged in this affidavit. The charge is criminal mischief under $200. It's never specifically alleged what specific damage or what the amount on the affidavit.
State, do you have a response?
Yes, Your Honor. The affidavit clearly states that there was damage to property. She didn't have permission to destroy the window, and we don't have to prove price at this point, just that something was there, because it's under $200. It's not required to have an exact price point at that point. That's for the restitution later on and how it's charged.
All right, I find probable cause exists because, as the state said, there is probable cause that there was damage, the window was shattered. There is not an amount, you're correct, but I think that if the state was charging a specific amount, they'd have to prove it.
Ma'am, excuse me. What's your name? Because I just don't want to say judge.
Judge Gibson, you can call me
Okay,
that.
Judge Gibson. I just want to state something out. This happened.
Let me talk to you first.
Oh.
So let me just tell you this before you say anything else. What your attorney is saying is everything that you say today is on the record and can be used against you. So today we're not making a determination about the facts or your guilt or whether the state's even going to charge this.
Right.
The only thing I'm doing is determining that there's probable cause based on this affidavit. So everything you say can be used against you at a later time, and that's why your attorney is saying he doesn't want you to speak.
Okay, I understand.
With that in mind, do you want to still talk?
Yes, I still want to talk
Okay.
because this all is because of my boyfriend, mom, and this is all bogus, because in my affidavit, my boyfriend mom was inside her house. All she did was hear glass shatter. She never saw me bust glass out her truck window. She was inside her house. She never saw me bust her truck window. I never did it. I never will, because for the simple fact, I have things going on myself, and especially with my 4 kids I have at home that has to go to school in the morning. So all I'm asking is, regardless if we resolve the case now or not, I just need to go home to my kids because they're home alone,
So we can't resolve the case today?
No.
And-
If you want to, we can. If you don't, I'm still pleading not guilty because my boyfriend already said that his mom wasn't coming to court and she called the people.
Right, so that's a determination that has to be made by the state of Florida. They're the ones bringing the charges.
Okay.
So if they decide not to file these charges, then the case will be resolved and you won't have to come back to court.
Thank you.
But we can't do that today, and I can't tell them what to do. That's
Right.
their purview.
Right,
So
okay.
today, I find that there is probable cause.
Okay.
There was breaking glass and a window was broken. We have a witness who says that you were there and that you were the one beating on the glass. I'm not saying that the state can prove this or, again, that the state is even going to file it. The only thing I'm doing at this point is saying that there is probable cause to believe that you did this.
Yes, ma'am.
So you're out on bond currently for delivery of cocaine. Is that you have 2 cases. I'm going to revoke those bonds, and I'll leave your bond in the criminal mischief case at $500. You're not allowed to have any contact with the victim, and you're not allowed to return to the scene of this incident. Do you understand that?
Okay, on the S&Ds, I'm supposed to come to court Tuesday for that.
You'll be in court on Tuesday then.
Okay.
All right, good luck, ma'am.
Thank you.
Sorry. Good afternoon, sir. Please tell me your name.
David Edward Mikulski.
All right, you're here in 2020 MM 734280, charged with violation of a domestic violence injunction.
Sorry, Vic, I print something that you.
That's all right.
It was me.
I'm going to appoint the public defender to represent you. Do you have a probable cause challenge in this case, sir?
No, Your Honor.
All right. I think that's wise. I do find probable cause exists in this case. Does he qualify for pretrial release?
Judge, it looks like we weren't able to reach the victim or any of his emergency contacts to verify any of the information that he provided to us. He's unemployed, so we weren't able to go off of employment. So he does have a low RA score and minimal criminal history.
Does the state wish to be heard on bond versus pretrial release?
Yes, Your Honor. I mean, I would just set a low bond with the nature of the charge being a violation of domestic injunction. That it was there, the facts that he did go to the house when he was supposed to be. I understand that there's not much history or anything. A low bond, monetary bond. I'd say $250.
Well, actually, the court is inclined to impose a $500 bond in this
$500.
case.
Yep.
You're not allowed to have any contact with the victims. You're not allowed to return to the scene of this incident. You're not allowed to possess weapons of any kind, including firearms or ammunition. Do you understand that, sir?
Yes.
Do you have any questions for the court?
No.
All right, good luck, sir. Yes. No contact, not return to the scene. No weapons. Good afternoon. Please tell me your name.
Giovanni Santos.
All right, sir. You're here in 2020 MM 734180. Appoint the public defender to represent you.
And
I
Your
find
Honor,
there.
we do have a probable cause challenge on this case.
Please proceed.
First on the
Please get very close to the microphone.
Yes, sorry. First on the giving false identification to law enforcement, Mr. Santos gave his name, Giovanni Santos. He also gave the name that comes up under the fingerprint scanner that the officer had of, it was Juan Sanchez, Your Honor. His mother showed up to the scene and said that his name is Giovanni Santos. Your Honor, there could just be I don't think at any time he gave the incorrect name or was trying to deceive law enforcement in any way. According to the arrest affidavit, I don't see that there's probable cause for that, that charge. Also, the marijuana, the cannabis charge, I don't believe there ever any determination of whether he had a medical marijuana card or a determination of whether the substance was hemp or another type of, leaf, Your Honor. And that's what we're challenging.
Does the state wish to be heard?
Yes, Your Honor. Just quickly on the possession of cannabis, that there's probable cause. There was a small green leafy substance found with a strong odor of cannabis coming from the defendant. It was found on his pants. The hempen card that's a defense. That's not going into this. That doesn't go into probable cause hearing. I believe there's probable cause of that. The providing false ID to law enforcement officer, the statute clearly says it's unlawful for a person who's been arrested or lawfully detained by a law enforcement officer to give a false name or otherwise falsely identify himself or herself in any way. And this time, the first time the officer approached, the defendant said that his name was Giovanni Santos with a date of birth of 10/22/2000. The second time, he gave a separate name of Juan Sanchez with a different name with a different birth date of 10/22/2001. There was an NCIC and FCIC check showed that there was no hit on either name with that date of birth. And then it was on the third time he did say his name was Giovanni Santos, combined with the first name. So he combined the names with the birth dates to 10/22/2001. Again, an NCIC and FCIC check showed no hit on this. If you combine that with the totality of the circumstance of his mother giving a separate name with a different birth date, that combination wasn't given. It took until they get the fingerprint scanner at the jail that they got a hit with, I believe, I'm not sure, Giovanni Santos, which is an AKA confirmed out of Miami, Juan Sanchez confirmed out of Miami on that point. But with all the totality of circumstances, his name changed multiple times, the date of birth changed multiple times. I think there was probable cause to charge that.
And Your Honor, both of those are his names. He's been arrested before, and that's why the Juan Sanchez comes up under the fingerprint. But that is his given name is Giovanni Santos.
Can I talk, ma'am?
You can, sir, but everything you say is on the record and could be used against you. So your attorney would probably tell you not to.
Your Honor, like I said before, the officer's records would show that a Juan Sanchez, his fingerprints would come back to Mr. Santos, but his given name is Giovanni Santos. In neither situation did he intentionally give a false identification to the officer. And I believe both names would be correct in this situation.
So that's a very creative argument because Juan Sanchez and Giovanni Santos are not at all similar names or derivative of each other. But also the date of births that he gave separate dates of birth, multiples, and the fingerprint check came back to Juan Sanchez, date of birth 10/15/2001, which is a date of birth that he never provided to law enforcement. At this time, I'm going to find probable cause exists on both counts. He qualifies for pretrial release. I'll put him on pretrial release. Sir, you're not allowed to consume drugs. If you have a medical marijuana card, you are allowed to consume that, but absent that card, you may not consume any drugs.
Okay, ma'am. Back in 2017, I had a brain injury in Georgia. I was hit by a police car, and they caused me a brain injury and my sister's death. So that's why I smoke. I don't smoke for any other reasons.
Okay.
And I had me a 4-month baby that just been born.
So if you have a medical marijuana card, if it's prescribed by a doctor, you can possess it. If it's not, you cannot possess it.
I just haven't got it because I'm 18. I'm not the age yet.
Okay,
to be.
so then you cannot possess it. Do you understand?
Yes, ma'am.
All right. So while you're out on pretrial release, they're going to do random drug screens to make sure that you're not smoking marijuana or any other illegal substances. Do you understand?
Yes, ma'am.
Okay. All right. Thank you, sir. Good luck. No. Good afternoon, sir. Please tell me your name. Sir, can you please tell me your name?
David William Stager.
Oh.
You know we said for tomorrow?
Who?
Yeah, you know we said.
Oh, yes, please do. All right, so David Stager, you're here in 2020 MM 733380. You're charged with trespass on property after warning. I'm going to appoint the public defender to represent you, sir. Does the public defender have a probable cause challenge?
No, Your Honor.
All right. I do find probable cause exists here. Sir, I show that you're out on bond on a resisting without violence case.
On resisting?
Yes.
Yes, Judge. I was adjudicated time served along with the trespass on the 8th 2 days ago. I was told I signed a court order to go to the courthouse on the 16th to watch a video, and that if I did, they would drop the charge altogether. But it was already adjudicated time served, and I wasn't told anything about an ROR. I signed a form to report to the courthouse next week on the 16th to watch the video. I was told that by my attorney before I went to court. But they said, no, how can you be R&R when the case has been adjudicated and given time served? I got 40 days time served on it.
All right, sir, I don't know about that case, but because it's an ROR, I'm not revoking that. So I'm going to take no action on that case. You'll have to talk with your attorney about whether it's been disposed of or not. I can't answer that for you today.
Will I be able to see the video on the 16th at the courthouse?
That's up to your attorney
Or if I
and
bond
the
out,
state
okay.
attorney who's prosecuting that case. In the trespass on property after warning, I'm going to leave your bond at $500. Special conditions, you're not allowed to return to the Walt Disney World Resort. Do you understand?
Yes.
Do not return there.
Yeah, I just went there to retrieve my wallet. My
Okay.
livelihood was in there. They told me they had it. When I got there, they were waiting for me and trespassed me again.
Okay, all right, well, don't go back there.
Can I bond that on file?
Sir.
Yeah, get more.
Good afternoon, sir. Please tell me your name.
Good afternoon, ma'am. Stephen Otaola.
All right, sir. You're here on an out-of-county warrant for burglary to a residence with a battery. There's no bond set on that warrant. I'm not going to disturb that warrant at this time.
Ma'am, I'm sorry.
I'm going to appoint the public defender to represent you. Do you have an attorney to represent you, sir?
No, ma'am, I don't have one.
Okay, I'm going to appoint the public defender to represent you on these cases, on this case, but you aren't able to bond out right now.
No?
No, your attorney will have to file a motion with the judge who signed the warrant. Good luck, sir.
What should I do?
Nicole Simmons refused.
She refused?
Yeah.
Oh. It's an out-of-county warrant? Yeah. Mr. Public Defender, in Nicole Simmons' case, I'm going to appoint you. Do you want to waive her appearance? That's case 18 CF 2958. It's an Osceola County warrant.
Yes, Your Honor.
All right. He waived her appearance. We'll have Judge Carter contact the other judge. Yes, bond stays at none. Good afternoon, sir. Can you please tell me your name?
Weisberry Cruz.
I'm sorry?
Weisberry Cruz.
All right, sir. You're here in 20 MM 701980. Did we reset this one? Because I believe in the public defender's already been appointed. Hospital. And probable cause determination's already been made and the public defender's already been appointed. So, sir, his bonds are already set, right?
She didn't mark.
I'm gonna leave your bond set at $500 on count 1 and $500 on count 2. All right, good luck, sir.
Thank you.
Mr. Harris is medical, and Mr. Zdrowski is medical also.
All right, do we reset them for tomorrow then? No, I don't want Judge Wish or Judge Carter to. Yeah, let's reset him for tomorrow. Who? We're resetting Robert Harris, and then who's next?
Zachary Zdrowski.
Okay. Wait, he was medical?
They got traps on this.
Okay. So now I have Matthew Hamilton.
Yes, ma'am.
Is that your name, sir?
Yes, yes,
Okay.
ma'am.
You're here in 1267580, 19 CF 1236280, 20 CF 153880, 19 CF 118090, and 20 CF 100880. So these are all violations of parole.
On probation, they, if you go to the next page,
Mhm.
go to the use advocacy report, it's correction here, correction form saying that the officer arrested him on parole, but it's actually.
But it's probation?
Yes.
All right, so the charge is violation of probation.
Yes, okay.
Okay. And on all of these warrants, the judge who signed the warrant set your bond at no bond. So I'm not going to change that this morning. You'll have to see that judge in order for that to be changed. I will appoint the public defender to represent you, and they can file a motion on your behalf.
Okay.
All right, good luck, sir. Good afternoon. Please tell me your name.
Kelly Siddick.
All right. Ms. Siddick, you're here in 18 CF 11805, 18 CF 12075, 18 CF 12073, 20 CF 12217, 20 CT 6322. I'm gonna appoint the public defender to represent you. It looks like 1, 2, 3. 3 violations of probation, a possession of cocaine, and a driving while license suspended. The violations of probation, you have no bond set in those cases, and I'm not going to disturb that. That will stay at no bond. In the possession of cocaine case, does the defense have a motion?
No, Your Honor.
Okay. I think that's wise. I do find probable cause exists in that case, and I'll leave your bond at $1,000. As to the driving while license suspended defense, do you wish to be heard?
I'm sorry, Your Honor. Were you addressing the defense?
On the Dwillis case, do you wish to be heard on probable cause?
No, Your Honor.
Again, I think that's wise. I do find probable cause exists, and I'll leave that bond at $500. Good luck, ma'am.
Thank you.
Is that everyone?
Corey Bentley. Bentley. 2002 2167 Bentley. Did we reset her?
I don't know no business. Oh, we did her, so, okay, I gotta look and see, let me look and see what I did with her.
I don't know.
Me?
Can I go off the record?
She was at the beginning?